All right. Ladies and gentlemen, dear guests, my name is Jan Dziurzyński and I'm the president of the University of Warsaw Moot Association, which is organizing today's conference. And it is my great pleasure to welcome you all to Collaboration in Arbitration, working with clients before and during the dispute. A conference that is held as part of the 17th Warsaw Pre-Moot, an event that has firmly secured its place at a global roadmap of preparation for the Wismut finals. Before we begin today's discussion, I would like to thank all the partners of this event, which are the Singapore International Arbitration Center, the Court of Arbitration at the Polish Chamber of Commerce, the Leviathan Court of Arbitration, the Faculty of Law and Administration at the University of Warsaw, and last but not least, the Mediation, Negotiation and Arbitration Student Association at the University of Warsaw. Thank you for bringing us all together to discuss very crucial and important topics. My gratitude is also extended to the speakers and moderators, and which expertise will shape our today's discussion. And most importantly, very warm welcome to all the Mooties who traveled here to Warsaw to participate in the Warsaw Pre-Moot. In the course of the next 2 days, 16 teams from 10 different countries will compete in 48 hearing rounds. May this experience help you prepare well for the finals in Hong Kong and Vienna, and most importantly, be a great memory of Warsaw and Wismut community. So, without further ado, let us begin our conference. And it is my great pleasure to welcome our very distinguished speaker who will deliver the opening remarks. Please welcome Professor Anna Zbiegiem-Turzańska, the Vice Dean of the Faculty of Law and Administration at University of Warsaw.
Ladies and gentlemen, distinguished guests, dear colleagues, arbitrators, students, and friends joining us here and online. It is my great pleasure and honor to welcome you to the conference Collaboration in Arbitration, working with the client before and during the dispute. This event is not only an academic and professional gathering, it marks also the official opening of the 17th Warsaw Pre-Moot, which brings together teams from different countries all across the world, from the Czech Republic, Germany, Finland, Georgia, Portugal, Switzerland, Italy, France, the United Kingdom. We are truly delighted to have you all here at the University of Warsaw. This event would not have been possible without the generous support and partnership of numerous institutions. A special warm welcome and a thankful words goes to the Singapore International Arbitration Center, to the Court of Arbitration at the Polish Chamber of Commerce, and the Arbitration Court at the Confederation Leviathan. Your presence and engagement elevate this conference and help cultivate the culture of high-quality legal education and international dialogue. Special thanks also to the University of Warsaw Moot Association and the Mediation, Negotiation and Arbitration Students Association. Please allow me to welcome all our distinguished guests, arbitrators, attorneys, panelists, speakers, who generously offer their time and expertise to our conference. Thank you for joining us. Thank you for sharing your experience and for supporting the next generation of arbitration practitioners. A particularly warm welcome goes to all students participating in this year's Pre-Moot. You have traveled from all across the world, and your commitment is inspiring. Pre-Moot and then Vismoot is more than just about competition. It's a formative experience, shaping skills, confidence, and professional ethics of future lawyers. The theme of today's conference, Collaboration in Arbitration, it touches the very heart of modern dispute resolution. Arbitration increasingly is about strategic cooperation among different groups of people, collaboration between legal attorneys, between in-house teams, between experts, and above all, between the clients themselves. Please allow me for a short story from my personal experience. When I entered the Warsaw Bar Association and I began my bar training, one of the lawyers who trained us at that time asked us a simple question: who is the biggest enemy of a legal attorney? And at that time we thought that the answer to this question depends on the role and the position in the dispute you are given. So we thought that if you represent the plaintiff, your main enemy would be the defendant. If, on the other hand, you represent the defendant, your main enemy would be the plaintiff. And I must tell you that our lecturer was very disappointed with the answer we have given. He told us that the answer to the question, who is the biggest enemy of a legal attorney, is always the same and very simple. It's your own client. To be honest, I believe that this is not always true. But that short story shows the significance of cooperation between the legal attorney and the client. It shows also the importance of their special and unique relationship. And this leads me to the topic of today's conference and of the panels we have. So the first panel, moderated by Antoni Żukowski, opens a crucial conversation on the relationship between external attorney and in-house teams. So this topic is often underappreciated, yet it seems crucial for effective dispute resolution. Then we will have a wonderful keynote session delivered by Vaktangi Giorgadze from the Singapore International Arbitration Center, which we are very fortunate to hear in about a few minutes. The second panel, how to prepare a company for a dispute before it even arises, will be moderated by Monica Deal, and it reminds us of dispute awareness. Probably it is as important as the dispute resolution itself. One general remark. So I must tell you that I'm very happy that this initiative brings together so many people. So we have practitioners, we have academics, we have students, we have arbitrators from all across the world. The topics and challenges that will be discussed today, how to collaborate, how to prevent disputes, how to develop dispute awareness, they transcend national systems and demand a global conversation. And I am particularly proud that my faculty, the Faculty of Law and Administration at the University of Warsaw, continues to serve as a platform for such a dialogue. The enthusiasm and professionalism of all our students from the University of Warsaw Moot Association and from the Mediation, Negotiation and Arbitration Students Association are key pillars of this success. And I would like to thank you sincerely for your commitment and efforts. Ladies and gentlemen, I wish you all inspiring discussions, productive exchanges, and a memorable experience throughout this conference and the upcoming Warsaw Pre-Moot. It is now my great pleasure to declare today's conference officially open. Thank you very much.
Professor, thank you for the opening remarks. And now let us dive into the first discussion round titled How to Cooperate Effectively in Arbitration, Law Firm and In-House Legal Department. And we are joined today by a panel of distinguished experts whose expertise will guide us through today's discussion. Leading the discussion as a moderator is Antoni Żukowski from BLSK Law Firm here in Warsaw. Please welcome our moderator and our distinguished speakers.
Thank you, Jan, for this brief introduction. Good afternoon, everyone. It's a great honor for me to be here today. And when I was approaching potential panelists for this panel, I had in mind the idea that we should balance this panel. So I think we have managed that to do it pretty well, because we have two external counsels and we have two internal legal counsels from large construction firms. So I will briefly introduce our panelists, but I think everyone has seen the booklet. On the left, far left from me, is sitting Piotr Golędzinowski. Piotr is partner at Wardyński and Partners Law Firm based here in Warsaw. Next is Agata Zwolankiewicz, associate Adershaw Goddard, also here in Warsaw. And next, our esteemed practitioners from the construction sector, Natalia Jodłowska, from the firm that I always admire the simplicity of the name, We Build. And Marcin Orecki, the name is much harder because it's a Turkish firm, Güler. Correct me, Marcin, if I'm wrong in this pronunciation. Am I right? Yeah, it's okay. But I think there are a few more Turkish firms with much harder names to actually say. So without further ado, I have divided this panel with my colleagues, because I'm proud to call you my colleagues, into a few sections. So we will start with a discussion about, I think it's at the beginning of every discussion in arbitration conference, how do we actually end in arbitration? So maybe this will be a question for Marcin first and Natalia. So what makes you decide to include arbitration clause in a contract? Do you actually do it or not? What are the key factors here when you are advising on some contract?
Now it should work. Thank you very much for kind invitation and introduction. As you notice, we both come from the construction sector, which is quite specific. And going straight to this question, I wish we could use more arbitration clause and more arbitration in our industry. Unfortunately, construction sector, especially in Poland, is much more litigation driven. So every kind of attempt to put arbitration clause into the contract is quite difficult. Of course, there are two kind of relation. First one, which we have with our clients, employers, public mainly employers. And in Poland, it's quite impossible to put arbitration clause in such a contract. I tried 3 times. It was in a specific kind of public tender procedure, small contract. When I received the draft of the contract, I was entitled to put their arbitration clause, proposing that it might be quite effective from the employer point of view. It might be cost effective, time effective. I simply received the feedback that the arbitration clause was crossed out with no comment. When I tried to understand why, because we received, of course, comments to our proposals of amendments to the contract, it was not possible to receive feedback regarding arbitration clause. But this is one side, of course. We have another aspect or side of our business activity with our subcontractors, suppliers, and other firms with whom we are cooperating. And unfortunately, we are also not very often using arbitration clauses, because it comes from the main idea that the main contract is based on the litigation. But it sometimes happened, especially when we have contracts outside of Europe, because this is not only typical for Poland, but the same we observe in Sweden, in Romania. It looks like that in Europe it's much more difficult to use it. Outside of Europe, it happens that it's more likely that we use arbitration, but it is also common that our employer, for example, in Dubai, we used arbitration clauses because our client also used arbitration clause. Why we use arbitration? Because it's faster, it's quite obvious. Even though the disputes in construction industry are quite complicated and it cannot be as fast as everyone would wish, it is still faster than litigation. So the main factor, I would say, is time. Not necessarily cost, not necessarily value of the dispute, not necessarily party with whom we are arguing. And second argument, let's say, favoring arbitration is, of course, language. I prefer to let's say, arbitrate in English in Sweden instead of using Swedish and translation to Polish or English in Swedish courts. So that's another factor which we take into consideration.
Thank you, Martin, for these remarks. Natalia, do you share this experience? Because I think it's obvious for that you are also working in Poland with Polish state entities. So I think you have the same experience, but please share this with us.
Yes, unfortunately, I share entirely this position. My company also works on the public procurement market, so this is generally published and public entities policy not to include arbitration clauses, and consequently, as Martin said, we don't feel it is effective to have different arbitration or generally dispute resolution clauses in our subcontracts. In some specific cases, as Martin also said, with specific entities, especially also foreign one, sometimes we indeed have different dispute resolution forums, including arbitration. Maybe another group of potential dispute where arbitration clauses actually are included in our contracts are consortium agreements, because then especially when we have consortium consisting of companies from different countries, from different legal systems, it is much easier to go to arbitration, and it is seen as more neutral forum to resolve our disputes. So yes, it is the main reason main reasons why we don't have or have arbitration clauses, at least in Poland, because as Martin also said, in different countries it works differently. But in Poland, this is the reality we have.
So for our foreign guests, this is not a good picture of Polish arbitration market, but maybe Agata will give us some remarks about her experience with foreign clients when it comes to why do your clients actually choose to arbitrate instead of going to state courts.
Hi, everyone. It is a pleasure to be here, so thank you so much for the introduction. And before I answer the question, let me just tell you that nostalgia hit a bit, because I just heard that this is the 17th pre-moot, and I just remembered myself sitting where you are sitting right now during the 10th Warsaw pre-moot, so it's a pleasure to be here. Time flies by. And now going straight to answer your question, yes, when it comes to foreign clients, we do see arbitration clauses, and we do see arbitration as the preferred method for dispute resolution. And that would be, in majority, going for the most popular arbitration institutions, so ICC, LCIA, VIAC in Vienna. I must say that when it comes to foreign clients, and this is unfortunate, this is something that we're trying to change, to educate our foreign partners a bit. They are not so inclined to choose Polish arbitration institutions, which in my view have a great long-standing, and the level of service is great. So we do try to implement those clauses on a larger scale. But when it comes to relationship with parties who are from different jurisdictions than Poland. I think the speed, given a lot of dissatisfaction with Polish courts when it comes to the effectiveness and speedy resolution of disputes, so the parties are inclined to choose arbitration. The costs when it comes to Polish arbitral institutions are not that much higher than before the national courts, and we must take into account the length of the proceedings. So at the end of the day, I would say that arbitration is not that much more expensive than litigation before national courts. Language, as we have heard from the in-house counsel perspective, and in general trust in arbitration institutions, in the neutrality, in the enforcement proceedings, because we must remember that arbitral awards, when it comes to jurisdictions which have signed the New York Convention, they're enforced in accordance with a uniform regime for enforcement of arbitral awards. So I would say that these are the factors that our clients take into account.
Thank you, Agata. So we are now left with Piotrek. Piotrek, I think I can remember one case when you had a pleasure to represent foreign contractor here in Poland. Of course, I'm not asking you to share the whole story here, but you're representing a lot of foreign clients here in Poland. So maybe you could also share your view about what was the factors that your clients were assessing when contracting in Poland and checking the possibility of using state courts or arbitral institutions here in Poland.
Sure. Well, we are at the University of Warsaw, so I will allow myself to be a little bit controversial, which I usually enjoy doing because it's for the benefit of the discussion. So also please don't treat every word of what I will be saying about as the truth carved in the stone, but I will try to present one of the possible angles of viewing it, one of the possible views of what one can have. So when it comes to foreign contractors, I think that the most important thing is to have a neutral and effective forum for dispute resolution. So that's basically what the contractors would be looking for, and as long as the state courts would be providing that, and there would be no doubt that they are providing that, I think the contractors would be relatively fine with adjudicating their disputes in the state courts, and quite often actually this is the presumption which they have when they are agreeing to these default clauses. To give you a little bit more of factual background how it works in practice, because many of you are quite young, many of you are outside of Poland. So about I would say 15 years ago, a decision was made that the biggest contracting authorities, the biggest employers in Poland, would actually cease to use arbitration as because the biggest contracts in Poland are usually construction contracts. The biggest investments are in the construction law regime, and very often FIDIC is used to supplement the terms of the contract. And then one of the default clauses in FIDIC is ICC arbitration, and that was also the default clause that used to be used by big contracting authorities, by big employers. But an active decision was made that they should actually start choosing Polish courts as the default solution for dispute resolution. One can wonder what were the reasons. Basically, I think that it's easier to explain to the CEOs that you are choosing why you lost despite choosing the Polish court. So even you couldn't have done any better. If you lose in arbitration, then maybe you must have made the active choice of choosing arbitration, and maybe this was the first reason that contributed to your ultimate loss in the case. So I think that it's much easier to explain why this is done so, and perhaps the way Polish courts handle cases are better understood by some of the in-house counsels. It's much more, a little bit more natural to them. What, however, happens now is that Polish judiciary is in a crisis, and we have the length of proceedings is actually extending quite a lot. So my personal opinion is that actually, as this trend continues, what you said, that in the construction contracts, the employers are not putting any arbitration clauses. In my view, this is actually, at this point, already acting to the detriment of their own clients, because they will not be able to effectively enforce any claims. Because what the employer, and usually it's the employer that has claims. So what the employer has they usually also have some security, so they have bonds, then they can take money from the bonds. But if they have state courts instead of arbitration in the contracts, usually the length of dispute would be, I don't know, at least 5 years in the first instance, maybe up to 10 years in the first instance, depending on the complexity of the dispute. So if you are looking at the proceedings that would last more than 5 years, potentially even 10 years, and only after that you are able to enforce any claims against the contractor, that's not really a remedy that can bring you any benefits in the short term. So what happens in Poland right now is that mediation and settlements are quite popular, because actually every employer realizes that they don't have any other choice. They can take money from the bonds, but they don't have any other choice. They have to settle everything else. So that's the reason of success of mediation. But I think that actually now arbitration becomes the very reasonable choice from the employer's perspective. That wasn't the case before. And from the foreign contractor's perspective, and even from the local constructor's perspective, what they're looking for is to have some kind of a level playing field against the employer. I would say that my recommendation in almost any type of dispute would be to go to arbitration, but that's my personal perspective, because I think I have more, besides everything that Agata mentioned, which were all very good points, is that I feel that I have much more control over the course of arbitration. I can choose and appoint one of the arbitrators. I have some influence of the appointment of the presiding arbitrator. Arbitrators have some procedural flexibility, as you may know. So as a party, you have also a lot of influence how the proceedings will proceed, how it will play out. So I think that for a professional good counsel, that gives you a lot of opportunity to properly present your case, and to have someone who will really understand that case when it will be decided. So that would be my point of view.
Thank you all for your answers. Sorry for the guests.
May I
yes,
interrupt? Sorry, because as a construction industry representative, I feel to make a statement, because Piotr mentioned FIDIC contracts in Poland. However, I would argue that the way and the level of modification and amendments used by our employers to this contract, we cannot use any more FIDIC contracts in Poland.
Yes, as people call them Polish FIDIC, because it's actually rewritten.
I would stick with Polish, without FIDIC.
So it's a case of Theseus ship. Okay, so thank you all for your answer. The brief picture of arbitration here in Poland, it's not quite good, but about Polish state courts, I think they are generally described as pro-arbitration. The tendency of annulment of arbitral awards in Poland is quite rare, so Polish state courts don't allow a lot of cases regarding the annulment of arbitral awards. And Piotr mentioned, it was a good point about when foreign contractor would actually go to state court if you are playing with set of rules that are clear and it might be a good option, but in few countries in Europe, we have this tendency that you can actually litigate in a state court in other language than the national language. So we have the Netherlands Commercial Court in Amsterdam, so you can go to the state court in Amsterdam and use English language as a procedural language in your state court, and I think Germany also introduced that, so maybe that will happen in Poland one day, I don't know, but maybe that would be a good idea for the foreign contractors. So we have discussed arbitration clauses, so let's imagine for a moment that you actually have an arbitration clause in a contract, and I will start again with Martin because you are a known advocate for settlements in the construction industry. Sorry for turning that panel a little bit into the construction cases panel, but that was my privilege as a moderator of this panel. So Martin, what actually makes you to start the arbitration? What's the decision behind your CEO, your directors in the company? What makes you to tell them that arbitration is a good idea?
Before I will answer to this question, just to help our moderator, we are focusing on the construction industry because the construction industry is generating, according to my experience, 80–90% of the disputes in Poland. So it's not because we prefer construction, but this is simply the statistics from the litigation and arbitration in itself.
Yeah, that's a good point, thank you.
And going back to this question, when we decide to go to arbitration or litigation, but arbitration, of course, this is the panel. Generally, as a company, we hate disputes. We hate arbitrations, and we always what we are doing, we do to de-escalate the dispute and to the perfect solution is to conclude an annex at the execution level of the contract. If we are not able to de-escalate to settle this case, the next step obviously is a settlement or mediation process. Once again, I must make a differentiation between two groups. First one is that in the private sector with our subcontractors, suppliers, whenever we are doing the private investments, 99% of our, let's say, possible disputes we are able to settle, either through annex or settlement, simply without even thinking of arbitration. It's much more problematic with the public sector, with the public employers, which is, of course, there is some reasoning behind this. Based on law, and we understand this, that our employers are also somehow bound. So we prefer to go to mediation, but sometimes it's simply impossible. And mainly we are using arbitration or litigation when we have to do this, when there is no other possibility. And we feel that we are entitled to get, for example, remuneration for the additional works, because at some level, we are also making such a evaluation whether it is viable to go to arbitration just to get at the end 1 million additional works instead of, let's say, destroying relation with the client. So that's maybe also a quite important comment which should be addressed at the very first question, that each dispute which we face is, let's say, separate, and we are executing a specific evaluation for the purpose what to do, how to behave, and in which direction we go. Then we decide to go to mediation or arbitration. I don't know whether you share this view or...
Yes, Natalia, please answer the question. Do you share this view?
Now I'm starting thinking that the Polish reality make us really mediation friendly and settlement friendly, because one could think that Turkish and Italian companies would be so different, and
no, we are negotiating and bargaining, so that's the main idea.
Generally, yes, our strategy is absolutely the same. Agreements, settlements are always our first choice, so we go to dispute only when we have to. Sometimes now maybe it's not so popular. Now we could start more easy mediation proceedings with public entities, but a few years ago it was more popular strategy that even directly requested, not officially, but our partners, there was request that first we need to initiate litigations, and once we have formal proceedings, we can start formal mediation, for example. So sometimes this is this kind of reason we need to start litigate or arbitration. In case of arbitration, sometimes due to the wording construction of the arbitration clauses or generally dispute arbitration clauses, we need to follow more strictly the deadlines. So sometimes this is also the reason that we need to start arbitration, not to lose some kind of claims.
So I think it was quite a strong statement by Martin that you hate disputes. So Agata, let's imagine
even though I know them.
So Agata, let's imagine your client actually hates disputes. What's your role there? Are you trying to change your client's mind regarding that quite strong statement?
Yes, so I even had, let's say, the opening line, how I would address this question. So as external counsel working in dispute resolution, you probably expect that I will say, we love disputes. This is something that we live off, actually. But this is not true, and I think the landscape has changed. We can see actually more pressing needs for dispute prevention, for some other alternative solutions for settlements, not necessarily engaging in a long dispute. So I would say when it comes to decision whether to actually start arbitration or litigation proceedings, this is of course on the one hand a legal approach, so to speak. So, of course, we must have the case assessment and the strength of the claim assessed. But on the other, I perceive this as a business decision, whether to actually engage in a long dispute and what are the chances, for example, to enforce our claims, not only the chances of winning. And I can see that dispute resolution lawyers are engaged at the previous stages of the dispute, so pre-arbitration phases more frequently. And on the one hand, I think that engaging an external counsel or in general a dispute resolution lawyer when it comes to the pre-arbitration stages, so negotiations, this may make the effectiveness of such dispute prevention steps better. On the other hand, it can also help to prepare for a dispute when you have lawyers on your side during the pre-arbitration stage. But I do hear that the client's interests are not really to engage in a dispute, and this is the last resort for many companies. Of course, we as lawyers and in general a dispute is a cost, so the company must assess all the factors before they actually make a decision whether to pursue a claim or not. So I would say now it all depends on the client's needs, and in my view this is more of a business decision. So we do consult, we do give our recommendations, but we are there at all steps along the way to help the client mitigate, prevent, mitigate, and then resolve the dispute.
Yes, Martin.
Sorry, let me tell you a secret, because Natalia and I, we are also, we have a background from the litigation arbitration practices, and believe me, the perspective which we are now discussing changes whenever you are sitting in at this place or that place. That's the reason why we are saying it.
Okay, so I will also ask Piotr about this issue. Have you also observed the change of tendencies about how your work is actually done? Are you engaged by the client in pre-dispute stages?
Yes, I did. I mean, I think that at least half of my work is on cases which either have not entered the full escalation stage or are escalating through mediation, for example. So that would be perhaps at least 50% of what I'm doing. I would say that I would fully agree with Agata. Very often this is, equally business decision, and sometimes, the councils, external councils might recommend initiating arbitration, but for some reason the business might be hesitant to follow that. Sometimes even the business might want to initiate arbitration, but the lawyers might be, actually the external lawyers might be hesitant to do that. I think that the most important thing is to really know what you are doing, and that's the message to you, that the only solution to know what you are doing is to have experience. So it's very important to start your career in a place where you can really learn from good practitioners who will explain, you know, what they are doing to you, and the rationale behind that, and will give you a glimpse behind the curtains of the process, and not only require you to, you know, provide some drafts. In general, when a client comes to an external lawyer, I think the most important thing is to, you know, gather all the information that the client's organization has, and then to assess what kind of additional information you may be missing, what kind of additional information the other party may have, and then try to craft some kind of a strategy to solve this issue. It might be the case that actually escalation and arbitration might be the only solution, or it actually might be a temporary solution to gain some leverage. But it actually also might be the case that you know, escalating might only bring you disadvantages. It might actually cause the other party to take steps you would like to avoid. So from my perspective, it's a case-by-case assessment of what would actually work the best in a given situation. I would say that construction business is very, you know, perhaps because of the complexity of the disputes, of also the costs that would be involved, is very eager to settle. I do a lot of other disputes in competition law, in post-M&A, and it's not always the case. I mean, sometimes people simply start hating each other and they want to fight. That also sometimes happens. They not always are as professional as big contractors, and they might, you know, but they might, even if you ask them to not escalate, they still think that this is the only way. So, I mean, it depends on the circumstances, and you know, you have to simply know and guide your client based on the client's preferences through the best solutions that are available. But it's ultimately, as Agata said, the client's decision what they will want to do based on your advice.
Thank you. Thank you, Piotr. So we have now established that there are quite a lot of factors that are driving the clients into arbitration or not. And I think we also now know that there are a lot of areas that you can actually cooperate with each other without going to the arbitration. But let's move with our case to the start of the arbitration. So choosing of an arbitrator, how do you approach that? Maybe we'll start with external counsels. Piotr, would you like to share your view about how do you do that? How do you engage with your client? Do you do that, or it's just your external counsel job to choose an arbitrator perfect for the case?
It happens that clients have some kind of preference. I usually don't like when this is the case, because I think that sometimes the reasons the clients have are a bit superficial, that they know someone, they think they know someone, or they like a person maybe whom they observed. So I try to usually I try to have my own list and discuss as far as possible also employ the client's preferences, but I think that picking the arbitrator is actually perhaps the most important decision you make during the dispute. So if I'm actually the external counsel and I'm actually supposed to be running the show, then I also must have control over the choice of the arbitrator. And if actually the client wants to impose an arbitrator onto me, then I think it's very important also to explain to the client that, well, okay, but then we share the burden of this decision. I mean, it's not only then, you know, in my view, this might diminish the probability of winning the case. I don't know by how much, but it adds to that. So, what would be my approach here? You know, I think that very often what I see discussing with clients, that people try to select for a very honest and dependable and reasonable lawyer. And I think it's generally a good choice. So that's one approach. However, my approach is a little bit more nuanced. I think that we have to have in mind that we are not selecting for a co-arbitrator, not the presiding arbitrator. So what's the role of a good co-arbitrator? This should be a person relatively flexible, because you don't know who will be a presiding arbitrator. So this should be a person who will be able to cooperate with a wide range of possible chairs that could be handling the dispute. That's one thing. Then that should be a person who will have some kind of, you know, personal, emotional flexibility to do that, but also intellectual flexibility, because you don't know actually who the chair will be. So this should be a person who will be able to adjust themselves, still remaining active and engaged. So that's actually the second thing. So I think it's very important that the co-arbitrator remains active and does not, but active in a smart way. So doesn't try to impose, you know, their ideas on the chair, but is able to bring their ideas into the discussion in a smart way to actually, you know, to influence how the tribunal operates. And the truth is that actually who is a good co-chair, you only see in the final award. I mean, you don't know that ahead of the time. You know it only in the, you see, you know, for example, what questions the arbitrators were asking during the hearing, how well they were prepared, how they cooperated with each other, and then what issues are actually reflected in the award, and what issues are discussed in what length, and so on. So it's to a very big degree a matter of experience to me, but, you know, experience based on active observation and selecting for this criteria which I mentioned.
So now everyone knows Piotr's strategy for choosing an arbitrator. Thank you, Piotr, for sharing this with us today. So maybe, Natalia, I will ask you a straightforward question. Do you like to have control over the process of choosing an arbitrator?
I like to feel I am part of the team. So maybe not actually the control, but yes, I like to participate in this process. And as a company, as in-house team, we do participate, but I believe it is more of the reason because of personal background of our internal lawyers, because both me in Poland and my, let's say, boss in headquarters, we have both strong arbitration background. So we like arbitration, we know the society, so we are happy to participate. But at the end of the day, we have for all arbitration, actually, external law firms who leading the case. So it's always, we are always listening to them, because it is actually them who has to face those arbitrators, have to cooperate with them. So it is important for us that they feel safe and confident with arbitrators we are choosing. So this is definitely our approach.
Marcin, care to comment?
I can agree with Natalia. The same is, this is how we understand. Then whenever we decide to proceed with the external law firm, they are leading. So we base on their assessment and evaluation. This is quite important, especially in investment arbitration, because as we know, there is kind of beauty contest for arbitrators, so we always base on the recommendations and comments from the law firm. However, what is important for me personally, especially is in the regular, so to speak, disputes regarding, more technical aspects of the dispute. I'm always saying that arbitration is, there are too many lawyers in arbitration, so I'm still going back to this romantic idea of arbitration that it should be at least partially more engineering commercial approach. So what is important for me is that to have experienced engineer or person who knows the business. This is
Marcin, have you seen such a case?
Yeah, I saw. It's rare, but it's possible. So
Me too, actually.
So please take this into consideration, and this is quite important because, as you also probably know, the arbitration is going, unfortunately, in this litigation style in many aspects, in many ways, in terms of formality, in terms of pleadings. So lawyers are bringing the everything what is good and bad, unfortunately, from litigation to arbitration. And the same is with arbitrators who are more focusing on the formal aspect of the award instead of focusing on the merits, which is quite important in our sector, technical aspects and those kind of elements.
Thank you.
I have to agree. Also, it is actually very rare, but I do face this kind of case once as arbitrator, where one co-arbitrator was engineer. Actually, it was a small case, but we finished it within 15 minutes during the first hearing, because the co-arbitrator was able to clarify all technical problems between parties, and the parties concluded settlement after those 15 minutes. So I recommend this approach.
So it's a shame that it actually happens so rarely. Agata, I know this might sound like a hard question, but do you recall any disagreement with your client about choosing the arbitrator for the case, or everything is going smooth with your clients?
So I would say it depends on the client, and I may just add that I do agree with Piotr that choosing the arbitrator, maybe it will not win your case, but sometimes it can cost you your case. And tomorrow you do not have a chance to actually appoint your arbitrators, so you will be able to see that in practice. Yes, sometimes. So we also had, I also had situations about which Piotr was mentioning, that sometimes the clients, they do have a name in mind, but perhaps we as external dispute resolution counsel, we do not necessarily perceive that arbitrator as suitable for this type of case. And I will just make a disclaimer that I am not a construction lawyer, so I do a variety of different disputes. So that would be, for example, one aspect. But the choice of an arbitrator starts not necessarily only with the name, but also with the nationality of the arbitrator. So that is the first decision to be made. Then the specific name. And we need to take a variety of factors in mind. So it's not only about the name itself, but the type of disputes they have experience in, the value of dispute, which also plays a role. Sometimes the high-profile arbitrators, they will not be interested in taking a small claims case. So that's also the factor that we do take into account. So when it comes to cooperating with the clients, I would say that, and I will go back to what Piotr has said, it's all about the transparency. It's our joint decision, but we as counsels, we do have to live with it. So we will have to be, facing all the procedural hurdles in the arbitration. So we, of course, do have an interest in choosing a person we do perceive as suitable for the task. So how we usually, in general, as dispute resolutions lawyer work, we, for example, provide a list of arbitrators. We do present profiles to the client. We discuss the pros and cons. Also, then ask the arbitrators, potential arbitrators, if they're even available to actually take on the case. So I would say it differs from client to client. Some want to be engaged more broadly. Some just, rely on the counsel. They come to external counsel. They trust the expertise, and it starts with choosing the arbitrator. And I will just add to sort of perhaps end this discussion, when it comes to the choice of arbitrators, if we cannot decide on a name, or for example, if the parties, if the co-arbitrators cannot agree on the presiding arbitrator, we do have appointing authorities. So some arbitral institutions, they act as an appointing authority, and they will choose an arbitrator for you.
Thank you, Agata, and thank you all for this part. I think we can agree that this part of arbitration is going pretty smooth for external and legal counsel. I'm just speaking about what you spoke. So let's flex our mind once again, and let's imagine that we are actually in the arbitration. The tribunal is chosen, the presiding arbitration is chosen, and you, external counselors, are preparing submissions. So, Piotr, do your clients engage at this stage? How do you work with your client when preparing your written submissions?
Well, definitely the clients have to provide information to us that based on which we can prepare the submissions. So, from my perspective, the most important aspect of working with an in-house counsel is actually to cooperate in that. And there is really a great difference, when you work with organizations without an in-house counsel, where you actually have to do that quasi-in-house job yourself. And then, when you cooperate with organizations with good in-house counsels that actually provide you, with everything that you need, they also very often know the organization very well, so their own organization very well, so they are able to actually give you more details about the potential dispute that usually you would be able to gather yourself. So that's a lot of value added. It very rarely happens to me that the clients provide inputs as part of submissions, so that usually wouldn't be the case. I mean, I think that relatively recently I had such a situation, but it turned out that the client's input is fully generated by AI, together with quotations from the case law. So it's also a little bit of a risk if you would rely on this kind of an input. So I think that if you were to receive that, you should be quite careful, because you don't know actually what's the level of proficiency in using that kind of tools by the counsels that your in-house counsels that you're cooperating with, especially if they're a little bit maybe new to that solutions. But definitely I also very much appreciate that they are reading through the draft submissions, they are providing their comments, and well, they are, I would say, one of the first judges of our submissions. So for me, that's very helpful and also very, very, very important in our cooperation.
Thank you, Piotr. We'll go back to the AI issue for sure, but I will ask Martin, how much autonomy are you giving to your external counsel at this stage when it comes to drafting submissions?
So this is a consequence of also, as we discussed, choosing of arbitrators. So they are preparing the case. Of course, our role is, we have two main roles. First, it is a kind of delivery role when we are collecting documents from the entire company and delivering in one package to the external counsel, just to let them, make them life easier and just to focus on merits. And the second is translation. I'm calling it translation from engineer language to lawyer language, I would say. I'm not saying that we understand everything, because we are not engineers, but we understand more than they understand. So at least we are trying to make it more friendly to them, because we understand that the critical element is to explain this to to arbitrators who are not necessarily engineers. Those are two main roles. Of course, we expect to receive a draft of the submission. Then we are reading it and accepting, of course, if there are some mistakes, big mistakes. We are just asking questions whether we are sure to write this or maybe not. But generally, we are giving autonomy to the external counsel because they are leading the case. They are doing their job. They are also responsible for that.
So, Agata, about your clients, how much of autonomy are you given in that area? Do you remember some case when your client tried to rewrite your whole submission after you sent a draft?
So I must say I don't recall such a situation, and I think the intensity of working with in-house counsel with the client, it depends from case to case. And I must say I do enjoy working with in-house lawyers, so I do always appreciate that opportunity. And as you said, Marcin, we do speak the same language. So for example, when I work directly with an engineer or someone from a specific industry, sometimes I need someone to actually translate that to me, so how to actually put it into the submission. I would say that this is a standard practice to, this has been shared by my colleagues, to have help when it comes to collection of documents, collection of evidence, and then this is a standard practice to prepare a draft, to not only let the in-house counsel comment on what you have prepared, but also to include questions. Do we understand this correctly? Is this evidence what we have attached? Does it really say this, what we want to prove here? So this is always a chance to have that double reviews, sort of to also make sure that we do understand the claims, we do understand the documents that have been provided to us. Sometimes there's a couple of rounds of comments, and from my perspective as an external counsel, it's very important to have very clear expectations, because sometimes it's not only the in-house counsel who will be reading, but also, as we have mentioned, I don't know, engineers or some specific industry experts. So I always like to clarify with the client in the beginning, how many rounds of comments are you expecting, who will be reviewing, who will be reading, how many comments will be going in. We are the pen holder, so we always have to include the comments of all the, let's say, specific groups of people that are commenting. So I think the only, let's say, aspect as an external counsel, I would really try to draw your attention to when you're organizing your works, is to really make sure to understand at the outset how many people will be commenting and how much of the autonomy they want over the draft. But as I said in the beginning, I do very much enjoy working with in-house counsels when we are preparing the submission.
Thank you, Agata, for that comment. So maybe Natalia, do you remember any disagreements with your external counsels when they delivered you some kind of submission and something went wrong?
No, maybe sometimes it's rather, if it is something very specific, rather brainstorm how to deal with some specific issues. But no, generally, this is the reason we go with external counsel, because we trust their specialization, their knowledge, their experience. So they are the ones that should show us the correct road. Of course, our involvement is more extensive at the beginning, from, as my former speaker said, because of gathering documentation, factual data, and so on. There are, I would say, at the later stage, there are two more aspects, or one is maybe not only at the later stages. There are some specific issues related to, for example, my corporation, my organization, which is foreign company acting in Poland through the branch. So there are specific issues that follow, for example, from Italian law. So there are these issues we need to manage in the same manner, not only in Poland, but all over the world. So this kind of topics we need to focus and control from our in-house perspective. And second, more human, let's say, topic is with witnesses. Of course, on construction market, a lot of our employees have great experience with courts as witnesses, but sometimes, you know, most of the people don't like go to courts. So I feel it is also my role to speak to our employees, my colleagues, and explain to them what will happen, because of course external lawyers follow the case on the merits, but they have no time sometimes, and it's not their role maybe, and maybe we just don't want to pay for that, but, you know, explain to our colleagues what will happen, how they should, you know, behave in the court, and just to make them feel that they don't have to be afraid.
So I think we can all agree that the cooperation at that stage is going pretty smooth. Let's move to the hearing in our case. So, Agata, have you ever been at a such hearing with your client, the in-house counsel? Do you care to comment on that?
Yes, I did have in-house counsel in some of the hearings, and we also had the representatives of the company as such, so not the in-house counsel only. And I would say that from my perspective, my approach to the hearing, I mean, I don't change my strategy when it comes to participation of the representatives of the client and in-house counsel. And in some cases, it is very, very helpful. So for example, they can comment, especially in, for example, construction cases or in some other industry-specific types of cases, they can comment directly on the evidence, on what the witnesses have been saying, on the documents presented to the witnesses, whether this is really the case. Of course, sometimes if the expert is in the hearing room, that would sort of replace the role of the in-house counsel in these instances. So I did have positive experience with participation of in-house counsel in a hearing, but I do imagine that it can also, and perhaps our in-house counsels can share a bit more, or Piotr, but I do imagine as a dispute resolution lawyer that sometimes the presence of the client in the room can create certain expectations of how the external counsel should behave, how they should be cross-examining the witness, etc. I haven't had these, fortunately, but I'm very curious whether my colleagues
So
have
maybe
had.
let's ask Martin, do you like to be at the hearing room to stress your external counsel a little bit?
Or examine. No, generally I agree with Natalia. So as long as our board or external counsel or witness from our company expressly ask to be there for different reasons, we are not participating. We are just, as I said, external counsel is running the case. They are responsible for that. And I also understand from my perspective or external lawyer's perspective that at some point they may be maybe not stressed, but it might be understood that they are checking them or examining them or whatever, and that's not my role. We are hiring professionals, so we believe them, we trust them. So the only purpose when we will, the reason why we will participate is, as I said, our board will ask to do this. External lawyer, because we had such a cases. This is what Agata said. There were some requests. Maybe you could be there to help us, during the hearing, to help us find some case, because as internal in-house lawyers, we know the case by heart, because in majority of cases we were at the project. So we have everything in our minds, so it might be helpful, but we respect that and expect that external lawyer will tell us this expectation. And of course, this is what Natalia also said, that some of our employees or witnesses, potential witnesses, may require this or expect to be with them in the courtroom, so arbitration room, sorry. So yes.
So Natalia, you managed to comment on the hearing issue before I have asked the question, but do you like to be at the hearing as an internal counsel, or you don't?
Generally, I usually don't attend hearings as internal counsel, and our approach will be again similar as Marcin mentioned. My motives to be present at arbitration hearing would be mostly my private fun to see that, especially it is in-person hearing in some nice place, but today it's not very often actually. So I'm not so eager anymore to participate in online hearings, but yeah, I would follow or internal or external request for that, and I understand because sometimes I am also a counsel for our dispute, so I understand that it might be a little bit more stressful if you have someone who is watching you. So it's not my intention to do so.
It's good to hear that. Piotr, do you have some kind of experience going with internal counsel to the hearing?
Yes, I would say that in an ideal situation, and this actually happens to be quite often the case, I don't see in-house counsel as someone external to my team. So in most of the cases, I would like to actually treat an in-house counsel like I would treat, for example, another partner in my law firm.
So that's the true cooperation.
Yeah, I mean true cooperation, and then if they want to attend, I'm fine with that. I think it's the most important thing that we have the strategy aligned, our roles discussed, distributed, and everyone knows what we are doing, because during the hearing, every member of the team at the hearing is very important. So also to you, you can already see that at this. You are already promoting, so you have noticed that even if you are not pleading, then you have still some work to do to help your co-counsel. So it's a little bit like that on real hearings. So even if you are a junior member of the team, you still have to be present. You still have to be, observing what's happening. You still have to be helpful as much as you can to your senior colleagues. And that I would say that would be my expectation, that if the in-house counsel attend, they would also be part of the team and are engaged. I think that's to the benefit of everyone. I mean, it happened to me that someone is there only because they were, instructed by the management to come. It's also fine, but I prefer this kind of relationship when we are cooperating as one team. But I think we should also be aware of circumstances which we perhaps haven't mentioned, or mentioned a little bit, that some lawyers, they really feel a lot of pressure from the clients. So you can really notice that some lawyers really behave differently when you meet them and discuss with them directly. And then when the client comes, they kind of present the case not to you, for example, if you are in negotiations, but rather to their client. So they are trying to kind of peacock a little bit and present, actually manage, use this opportunity to manage their own relationship with their client, to present themselves as best as they can. I think that it's very important to be aware of this kind of even unconscious bias, because everyone might have this kind of tendency, but it's really not helping solving the matter. It's very important to be focused on solving the matter, not how you will be perceived by your client. But I think that really it's very prevalent, to my experience at least, that you can see that maybe not even during the hearings, but also any kind of negotiation, mediation sessions, the lawyers are taking part in.
Thank you, Piotr, for remarks. We are running a little bit late, so maybe last question, and I would like you all to answer maybe in one sentence. What's the most, the key element in successful cooperation between internal and external counsel? Maybe Marcin. I know it's a hard question to answer, especially in one sentence.
I would say it's easy. It's trust, simply, because when we have a trust and confidence in our council, then everything goes smoothly.
Natalia, trust also for you is the most important?
I would maybe add communication, but it is connected, because if communication is not the best, we can lose trust. And with good communication, trust, we can build better trust in our councils.
So trust and communication. Agata, do you have anything to add here?
Yes, it's difficult not to mention what has been said before. So I think I would add to this transparency, and I will just stop with that.
Piotr?
I think this is, obviously I have the toughest task, but I think that this is simply a type of relationship. So it's like with every relationship, you need trust, you need communication, you need transparency. I would maybe add reliability, but you know, it's all these things, and you know, they don't. Each of them describes one of the aspects of how you want the other person to behave towards you, and that's basically it.
And sometimes we also need a little bit of chemistry. So maybe I will ask the audience, do you have any questions for our esteemed panelists?
Okay, so I may ask a question. So you pictured generally your relation with the internal council as really good. Could you briefly share us one story that shows maybe the other story?
When a client did not pay, probably.
No, this, I didn't want to say this, but of course sometimes it happens.
No, I know.
No, but I just wanted to say that, and perhaps it's not a super bad story that, you know, it would be interesting to you, but I will go back to what I said before. I think the lack of clarity on what is expected, and for example, turning the comments by the client on the day of the filing. So I think these are the most stressful situations to me as the external counsel, and of course, we must take these comments into consideration, but at the end of the day, I mean, it's running a bit too late. You know, there's the time pressure, midnight is striking, and then, you know, the comments are coming in. So I would say that these are the types of situations I would describe as the bad experience.
Maybe not bad experience, but the part that might be difficult is costs. Yeah, cost of legal services. And one thing, for example, maybe it's sometimes difficult for external lawyers to understand, but we have budgets. And sometimes it's more important than level of legal services, unfortunately. It is important for us to try at least try to foresee further costs. And I understand, I was there, that especially when we're talking about long litigation that last years, it is difficult to foresee the cost of entire proceedings that last so long, but for clients it is important to have those costs somehow summarized, at least for coming months, years, coming year. So this is something that we expect some flexibility, and be open-minded by our law firms, and the different law firms have different approach towards that.
I can add two examples. One example, both would be about communication. So, for example, I had a situation where general counsel for Europe of a big corporation, we were working on a potential dispute. He wanted something from us and from a German law firm, and needed that very urgently to present to the group general counsel. But I think that this person was under a lot of pressure, so maybe we kind of miscommunicated about the requests, and that in the fact that this European General Counsel was quite dissatisfied with what they received. I mean, we had to work, do an all-nighter to prepare it once again according to more specified requests. But I think it really is very important to understand, to be certain that you fully understand the requests, and that is very, also even working internally within a firm, it's very important for you to really be sure that you know what you were asked to do. And that also works the same with the in-house counsel and external counsel relationship. And other example would be that I was requested to assess chances for winning a litigation, and I was requested twice. And after the second time was after about 6 months, and I had an impression that I was kind of describing the chances more or less the same. But the in-house counsel got an impression that I kind of changed my mind, and was really, really shaken by this, because I think he or she had reported that earlier, internally, and then they thought that maybe somehow our assessment has changed. So it kind of, I was quite surprised by the reaction, because for me it was more or less the same, but for them the very small change in the tone actually of how I described that changed a lot. So it also gave me a glimpse into that you have to also be very consistent in your advice. So it's and very rating something, because for you it's one of, like, I don't know, maybe 20 cases that I handle. So for me, I basically have an idea about it, but I'm not really living it, but on a daily basis. But maybe for this one in-house counsel, this is the only case they have in Poland, for example. And they also have to report that to someone. They have to be very consistent in that. There might be discussions I'm not aware of. So it's very important to be consistent, very diligent in how you also provide information because you are assessed from angles which you would not actually expect. So that's my experience.
Marcin, any bad experience? Because
unfortunately, yes. Unfortunately, yes. When we had one situation when our external lawyer engaged us too much. I mean, I had the feeling that we were written pleading together with them. It looked like that we were asked to organize a meeting with engineers with us just to explain the facts, etc., which is quite obvious and understandable. However, the meeting was all day long. That was another day-long meeting. So at the end, we spent 1 week, and after 1 week, we prepared together written pleading, and still the facts were not clear to our counsel. So that's the way, the difference and the line which should not be crossed, whether we are just reading the product and reviewing, and that's the goal, instead of just writing together, because we are not paying for this.
So if there are no more questions, thank you all for your responses to my hard questions. From my side, I know quite a lot of cases that went south, and actually I'm going to decide one of them in a disciplinary court at the Warsaw Bar Association in half an hour. So thank you, thank you all for this discussion, and good luck to our foreign guest at the Warsaw Primo tomorrow and on Sunday. Thank you very much.
Thank you very much to our speakers and moderator. And now I would like to invite you for a quick coffee break. You can grab a coffee, and snacks is just in front of this auditorium in the hall, and we'll see each other in 15 minutes. Thank you. All right, so we are after the coffee break, and I'm very happy to introduce our speaker for the keynote speech. Vako Giorgatze is a counsel and team lead at the Singapore International Arbitration Center. He's a qualified lawyer in Georgia and also a accredited mediator in Singapore International Mediation Institute. And Vako's experience also includes working for legal affairs division in World Trade Organization, working in top-tier Georgian law firm, and working for the Ministry of Justice of Georgia. Please welcome Vako Giorgatze.
Thank you, Jan. Thank you for the kind introduction. I hope everybody can hear me. And good afternoon, everyone. It's a great honor and privilege to join you today from Singapore as a keynote speaker. I'm sincerely grateful to the organizers for this opportunity and for the work they have done in bringing this conference together. Well, my only regret is that I'm not there in person with you in Poland, but nonetheless, I'm delighted to join you today and to contribute to today's discussion. I'm particularly delighted to address you because I know exactly how challenging and how exciting participating in Wismut can be. I participated in the 2013-2014 edition of Wismut in Vienna, and then I can say with full confidence that those experiences remain among the most formative of my professional career and life. So to all the participant teams, I wish you success, and more importantly, I encourage you to enjoy the entire journey and not just the final result. I'm joining you today from Singapore, as I said, where it is midnight right now, which feels like a modest reenactment of my own Wismut preparation days. I did have a couple of espresso shots, so I think I'm gonna be fine today. Let me just share my screen with you. So I have prepared the presentation. So in the next half an hour or so, I will speak about innovative time and cost-saving tools under the SIC Rules 2025. I also wish to give the audience a brief overview of the institution. So SIC commenced its operations in 1991 as an independent and non-for-profit organization. We have an average of 600 cases annually and an active caseload of 800 to 1,000 cases. Over 90% of SIC's cases are international, and the parties have come from more than 100 jurisdictions over the last 5 years. SIC awards have been enforced across many jurisdictions, including in Europe, and SIC rules ensure efficiency, cost-effectiveness, flexibility, and they are easily acceptable to both civil and common law practitioners and arbitrators. Case administration is done from Singapore, and I am based in Singapore. However, we have global offices in India, US, China, and Korea. As mentioned, users in SIC administered arbitrations have come from more than 100 jurisdictions in the last 5 years, and you see on your screen, including from my own country, which is Georgia. So in 2024, top 10 foreign users at SIC included South Korea, China, India, Hong Kong, US, Indonesia, Japan, UAE, UK, and Australia. So in 2024, the total sum in dispute for all new case filings was USD almost 12 billion. And the highest sum in dispute for a single administered case in 2024 was USD 2.6 billion. and an average value for all new case filings in 2024 was USD 31.6 million. Okay, so on 1st January 2025, SIC released the 7th edition of its arbitration rules. So SIC Rules 2025 provide various procedural tools intended to enhance time and cost efficiency in resolving disputes. These tools include the emergency arbitrator procedure, expedited procedure, streamlined procedure, early dismissal, joinder and consolidation, coordinated proceedings, preliminary determination, and the ARB-MED-ARB protocol. So I will start with pre-constitution applications, and I have to speak about emergency arbitration, and of course I have to mention protective preliminary orders, which is a novel feature in the SIC Rules 2025, and I'm sure audience will have some questions about this tool, so we call that PPO short. So let's start with emergency arbitration procedure. So emergency arbitration is one of the most popular procedural tools used by SIC users. A party that wishes to obtain emergency interim relief must file with the registrar an application seeking the appointment of the EA, so either prior to or concurrent with the filing of a notice of arbitration, or at any time prior to the constitution of the tribunal. So something to note here is that pursuant to SIC Rules 2016, which is a previous editions of the SIC Rules, an application for emergency arbitration could only be made at the same time of filing a notice of arbitration or following the commencement of an arbitration, but prior to the constitution of the tribunal. Now the SIC Rules 2025 have changed this approach, and the party now can submit an application for emergency arbitration prior to filing a notice of arbitration, right? So in such a case, a notice of arbitration must be submitted within 7 days from the registrar's receipt of the application for emergency arbitration. Otherwise, the application will be deemed as withdrawn on a without prejudice basis, unless, of course, the registrar extends this time. Well, I think it goes without saying, but if the tribunal is already constituted, then any application for interim relief should be made to the tribunal, and there is no need to make any emergency application for emergency interim relief. Now, we receive a complete application, right, which includes the payment of necessary fees. The president of the SIC court is briefed on the application, and then if the president determines the SIC should accept the applications, and the president determines this in her discretion. The SIC Rules 2025 states that the president will seek to appoint an emergency arbitrator within 1 day, 24 hours, right, from the later of either the date of receipt of the application or the date of receipt of the payment of the filing fee and deposits. And I can tell you that 24 hours is the tight deadline. I have dealt with a number of EA applications in the last 4 years, and it does put a lot of pressure on us, but I think we've been handling the EA applications really well. And usually EA applications come on Friday at 6 p.m., but today I don't think we have received any EA application. So now, okay, the SIC Rules 2016, under SIC Rules 2016, an application for emergency arbitration could not be made on an ex parte basis, right? I think so the SIC Rules 2016 had this general rule that the party must, at the same time as it filed the application with the registrar, send a copy of the application to all the other parties. Well, the SIC Rules 2025, of course, contain this general provision that all the parties have to be notified of the application of the EA application, but there is an exception. There is a limited exception from this general rule. Party now have this ability and option to seek and obtain a protective preliminary order, or as we call it, PPO, from the EA on an ex parte basis, directing a party not to frustrate the purpose of the emergency interim relief. This is a novel feature, I believe, across all major institutions. And if the president accepts the application in her discretion, well, we will appoint the EA within 24 hours, and then EA himself or herself shall determine the application for a PPO within 24 hours from the appointment. So again, I will repeat that this is just a preliminary order. This is not the final order that the EA will make. This is a preliminary protective order, which is this application will work in exceptional cases, right? Which is made on an ex parte basis. So now, okay, the EA made this preliminary protective order. And then the SIC Secretariat will transmit EA's order to all the parties to the arbitration. This is key here, right? So within 12 hours then from the SIC Secretariat's transmission of the EA's preliminary order, the applicant shall deliver a copy of all case papers, including the EA order and any other communication, including the recording of a hearing to all the parties. Now, the EA's preliminary order will expire in 3 days after the date on which it was issued if the applicant fails to furnish the statement or explanation regarding the delivery of the case paper to all the parties in the arbitration. So to safeguard the opportunity for all parties to present their case, the EA is required to provide an opportunity for all the parties to present their case and to deal with any objection against PPO at the earliest practicable time. And then any PPO will expire one way or another within 14 days from the date of its issuance, because 14 days is the deadline when the EA shall make the final either the order or award. Right? This is just a preliminary protective order, which is applicable only in exceptional cases. And I'm happy to answer any questions after the presentation if the time allows, because I know that this is a novel feature and then the audience may have some questions. Let's move on to other pre-constitution applications, and I will start with a streamlined procedure, which is, again, I believe it's one of a kind procedural tool across all major arbitration institutions. So it is designed for low-value disputes of low complexity. Now, the SIC rules on streamlined procedure prescribe that a sole arbitrator shall be appointed and the final award shall be made within 3 months from the date of the constitution of the tribunal. And in principle, the dispute shall be decided on a documents-only basis, and no party shall be entitled to make, and in principle, no party shall be entitled to make requests for the document production or to file any fact or expert witness evidence. And any hearing, if there is a hearing to begin with, to be conducted virtually. That's a default rule. So the streamlined procedure applies in 2 cases. First, if the parties have agreed to the application of the streamlined procedure prior to the constitution of the tribunal. That's key here, right? So the parties' agreement has to come prior to the constitution of the tribunal. That's the first ground. And the second ground is it applies automatically if the sum in dispute does not exceed SGD 1 million, again, prior to the constitution of the tribunal. With a caveat that unless president of the SIC court determines based on an application of a party, the streamlined procedure shall not apply. Right, so you may ask, okay, how does it actually work? So the thing is, when we receive notice of arbitration, we check, okay, what's the amount in dispute, because the claimant has to quantify its claims in the notice of arbitration, and we see in the notice of arbitration that the total amount in dispute is below 1 million Singapore dollar. And when we issue commencement letter, we will draw the parties' attention to the provisions on streamlined procedure, and then we will invite the parties' views. That's a general position. And of course, if the parties agree that they say that we don't want streamlined procedure, that's fine. But generally speaking, it applies automatically to disputes where the sum in dispute is under 1 million Singapore dollar. And it is designed, of course, low value disputes that are not complex really. And then the tribunal, this is an important feature here, that the tribunals and our fees, the tribunals and SIC's fees, kept at 50% of maximum payable to the tribunal and SIC under our schedule of fees, which means that the SIC's fees and tribunal's fees are halved. And I think it is great news for small and medium-sized enterprises to arbitrate their claims that are low value and do not really require the more than 3 months. Expedited procedure, another popular procedural tool which is intended to provide, again, a fast-track arbitration process for disputes of a smaller value. Okay, now here, right, so in expedited procedure, the final award shall be made within 6 months. 6 months from the constitution of the tribunal. That's also key, right? So the final award shall be made within 6 months from the constitution of the tribunal, and the sole arbitrator shall be appointed unless there's a caveat, and unless the president decides, based on the views of the parties, that the three arbitrator ought to be appointed. But that doesn't really happen often. In the last 4 years that since I joined SIC, expedited procedure is a very popular tool, and then sole arbitrator is appointed in absolute majority of the cases. Even if, I think I will mention here, and even if the arbitration agreement provides contrary terms, and then in expedited procedure provisions as well as in streamlined procedure provisions, there is a special rule which says that the provisions on expedited procedure, on provisions on streamlined procedure, take precedence over any contrary terms which may exist in the arbitration agreement, including the number of arbitrators to be appointed. Now, expedited procedure, generally speaking, is granted on an application, based on an application that is made by a party, and it is the president of the OSIC court that decides this application. There are 3 grounds, as you can see on the screen. The most common ground is that the amount in dispute is between 1 million and 10 million SGD. And the reason why this is between 1 million and 10 million, because streamlined procedure applies to disputes under 1 million Singapore dollars. That's the first ground. Now, the second ground is, for whatever reason, based on the application of a party, the president decides that the streamlined procedure shall not apply. Well, in that case, the party still can apply for expedited procedure. That's the second ground. And the third ground is if the circumstances of the case warrant the grant of the expedited procedure, which is a broad ground, really. These are separate grounds, but okay, what if the parties have agreed to the application of the expedited procedure? Well, in that sense, if the parties have agreed to the application of the expedited procedure, there is no need to make a separate application. In that, our rules expressly say that if there is an agreement by the parties to conduct arbitration under expedited procedure, then expedited procedure shall apply. And you may ask the question, okay, where can we find this agreement on the expedited procedure? Well, usually, right, it is fairly common that when we receive notice of arbitration agreement expressly provide the parties agreement to conduct arbitration under expedited procedure. And then, of course, if we see that, in the commencement letter, we will notify the parties that the arbitration will be conducted under expedited procedure. Well, of course, parties agreement can come after commencement of arbitration. Let's say one party suggests the application of the expedited procedure in official communication, and then the other party agree that that's fine as well. Okay, so both streamlined procedure and expedited procedure, both these are great procedural tools which are designed for low value disputes and low complexity. But there are differences, of course, as you might have noticed in the last 10 minutes. And I will just, again, for the audience benefit, I will just sum up some of the major differences, right? So in the streamlined procedure, there are two criteria. One is that if the parties agree to the application of the streamlined procedure, which is fairly, I mean, it's quite obvious. The second one is, though, when the streamlined procedure applies automatically to disputes under $1 million, unless the president decides to opt out of the application of the streamlined procedure. When it comes to expedited procedure, it is granted based on the application of a party and based on the views of the parties, but there are three grounds, as you see on the screen. And of course, if the parties agree to the application of the streamlined expedited procedure will apply in that arbitration. Sole arbitrator shall be appointed in both streamlined procedure, expedited procedure. Well, in streamlined procedure, sole arbitrator to be appointed in all cases, but there is a possibility of appointment. Free arbitrator doesn't really happen often. I have not seen, to be honest, that case. It's usually sole arbitrator. And then, of course, the final award in the streamlined procedure shall be made in 3 months from the constitution of the tribunal. In expedited procedure, 6 months from the constitution of the tribunal. And then the cost, which is, again, great news for small and medium-sized enterprises. In streamlined procedure, tribunals and assizes fees are halved. In expedited procedure, normal schedule of fees apply. Okay, so now let's move on to some joinder, consolidation, and coordination proceedings. I will not spend too much time on joinder and consolidation applications, as I'm sure the audience are perfectly aware of these applications. These are very popular procedural tools for SIS users. In brief, joinder allows a non-party to join the arbitration, non-party to join arbitration, and the consolidation allows multiple related arbitrations to be consolidated into a single arbitration, and both have advantages, a number of advantages, including the avoidance of contradictory or inconsistent decisions in interrelated proceedings. Coordinated proceedings, right? So this is another innovative procedural tool that has been introduced in the SIC Rules 2025. The idea of which is to promote efficiency in the conduct of arbitrations where consolidation or joinder may not be appropriate, right? So, okay, if consolidation and the joinder are not appropriate, now this tool, this coordination proceedings, this procedural tool allows multiple arbitrations, right? Where the same tribunal is constituted in 2 or more arbitration, and that's key, that where same tribunal is constituted in 2 or more arbitrations, and the common question of law or fact arises out of or in connection with these arbitrations. So a party to the arbitrations may apply to the tribunal for the arbitrations to be coordinated such that the arbitration shall be conducted concurrently or sequentially, or the arbitration shall be heard together and any procedural aspect shall be aligned, and any arbitration shall be suspended pending a determination in any of the other arbitrations. Well, in principle, any coordinated arbitration shall remain separate proceedings, and the tribunal shall issue separate decisions in each arbitration. And then, of course, the tribunal bear in mind the confidentiality obligations in each of these arbitration. Something to mention here as well, that so the joinder and consolidation applications can be made either prior to the constitution of the tribunal or after the constitution of the tribunal. If the tribunal is constituted, it is the tribunal that decides this application. But if the tribunal is not constituted, then a SIC court will make the decision. When it comes to coordinated proceedings, this application shall be made to the tribunal, and it's the tribunal that decides on this application. So we already mentioned coordinated proceedings let's now move to early dismissal and preliminary determination. Well, early dismissal, again, it's a well-known procedural tool for SIS users, and I'm not gonna spend too much time. The idea, as you all know, is to address delay and costs. So the procedure basically empowers tribunals to dispose of claims and defenses that are manifestly without legal merit in summary form without having to conduct a full-blown arbitration. Now, preliminary determination, that's something, a novel feature in SIC rules 2025. Well, now the SIC rules 2025 explicitly provides for the tribunal's inherent power to make a final and binding preliminary determination. I think most of us or all of us will agree that preliminary determination is something that is in tribunal's inherent power to make such a preliminary determination on an issue of law or fact. But here the idea is that the SIC rules explicitly provides now that this tribunal's inherent power, and the parties can apply to the tribunal if, and there are the three grounds here. If the parties agree, of course, which is, again, if the parties agree, that is fine. If the parties agree for the tribunal to make a preliminary determination on any issue, or if the applicant is somehow able to demonstrate that the determination of the issue on a preliminary basis is likely to contribute to savings of time and costs and more efficient and expeditious resolution of the dispute. And the third broad ground is when the circumstances of the case warrant the application of this preliminary determination process. Something I will, the couple of things here which is important. As I mentioned, these are the applications, both early dismissal and preliminary determination are post-constitution applications, and they have to be made to the tribunal, and it's the tribunal that makes the decision in its discretion. First, to allow this application to proceed, and if the tribunal allows the application to proceed, there's a specific timeline within which the tribunal has to make the decision on either early dismissal or preliminary determination. Okay, something to mention here, which is quite important for us, is that I think we are one of the few institutions with a formal scrutiny process to enhance the enforceability of arbitral awards. In SIC arbitrations, no award shall be made by the tribunal unless it has been approved and reviewed by the registrar of the SIC court. All awards, including the partial, consent, interim, are subject to the formal scrutiny process. And the main purpose of the scrutiny is to ensure, well, we cannot really ensure, but the idea is to enhance the enforceability of arbitral awards and to make sure that the awards are of high quality. Of course, at the end of the day, it's the tribunal's decision, but we make recommendations, and in my experience, tribunals more often than not welcome our comments. Now, because of the scrutiny process, we are really able to dial in fix the cost of the arbitration in a way that is commensurate with the work actually performed, and we are not really reliant on hours claimed or specific milestones. So as you may know, the cost of the arbitration are determined in SIS arbitration on an ad valorem basis. And in the beginning of every arbitration, we ascertain estimated costs. However, once the proceedings are over, we determine the actual cost of the arbitration, which is a holistic process. The determination of the cost of the arbitration is a holistic process as we take into account everything, really, including the stage of the proceedings at which the arbitration is concluded. As an example, if the parties settle the case after the submission of the statement of claim and defense, the cost of the arbitration, of course, will be considerably less. Let's say if the tribunal renders an award, or the parties settle the case after the evidentiary hearing. I mentioned that a registrar plays a key role in the cost determination process, and then it's a holistic, the cost determination process is a holistic exercise, really, and we definitely take into account the quality of the draft award to be scrutinized and the overall and efficient conduct of the proceedings by the tribunal. I'm not going to spend too much time on this slide. I will just mention a few other innovations in the SIC rules 2025, which includes the parties now express obligation. SIC rules 2025 now provides an express obligation of a party to make disclosure in relation to third-party funding. The prima facie jurisdictional objections, and the registrar has the registrar has the power to refer prima facie jurisdictional objections to the SIC court for determination prior to the Constitutional Tribunal. This provision existed in SIC Rules 2016, but SIC Rules 2025 enhanced these provisions. The novel feature in SIC Rules 2025, which is a registrar's power to convene an administrative conference prior to the constitution of the tribunal to discuss procedural directions. Mediation provisions. There are several prompts in SIC Rules 2025 for the parties to consider settlement of their dispute, including via arbitration, mediation, arbitration protocol, which I will mention in just a second. And finally, SIC Gateway. So I think I have to mention a few words about SIC Gateway. We launched a digital case management platform we call it SIC Gateway, for the convenience of the parties and the tribunals. So it is a cloud-based case management platform offering features such as electronic filing and integrated online payment system. So parties can submit if the parties agree to use the SIC Gateway. First of all, there is no additional costs. It is for the tribunals and parties' convenience. They can submit their submissions via SIC Gateway, and it is really convenient. The more and more parties are using SIC Gateway. My experience is since we launched this last year. I mentioned something about mediation and early settlement of disputes in the arbitration proceedings, and I have to mention that mediation is very close to my heart, and I think it's safe to say that mediation has gained more momentum in recent years in the resolution of cross-border disputes, especially in light of the adoption of the United Nations Convention on International Settlement Agreements resulting from mediation, or as otherwise known as the Singapore Convention on Mediation. Both arbitration and mediation have their own advantages, and I will not go into details. What I will say though is that this arbitration protocol, which is promulgated by us, SIC, and Singapore International Arbitration Center, which is another institution, combines the best of the both worlds into a single proceeding, where a dispute is first referred to arbitration before mediation is attempted. Right, so following the constitution of the tribunal and the exchange of notice of arbitration and the response to the notice of arbitration, the dispute is referred to mediation first, where the parties have about 8 weeks to try to settle their dispute. If the parties settle their dispute, which is fantastic news, they can ask the tribunal to record the settlement as a consent arbitral award. And as all of you are aware, consent arbitral awards enjoy the enforceability, generally enjoy enforceability of New York Convention. Let's say the parties cannot agree or cannot settle the dispute. That's fine. The tribunal is already constituted, then the arbitration proceedings will be resumed quite efficiently, because again, the tribunal is already constituted. And if they require more than 8 weeks, that's fine as well. That can be extended, but the whole idea is that the parties will have about 8 weeks. The last procedural tool that I want to mention briefly is something that we adopted last year. Again, this is a quite novel tool. So we launched the SIC Restructuring and Insolvency Arbitration Protocol in August 2025, which is a specially designed mechanism and framework to provide a procedure for arbitration at SIC for disputes arising in the context of restructuring, adjustment of debt, or insolvency. Right, so we adopted this protocol together with guidance note for parties and tribunals on cases that are administered under this protocol. This guidance note is for the convenience of the parties and the tribunals, and it's not mandatory, of course. We have adopted model arbitration clauses, as well as we create a specialist panel for restructuring and insolvency disputes. Bear in mind that parties don't need to appoint someone from this specialist panel, but it is there for the parties' convenience, of course. And as you see on your screen, it provides simplified procedure with a sole arbitrator to be appointed, and then possibility of settling the dispute. There are a few provisions on mediation and early settlement. And the idea is that final award shall be made, generally the final award is to be made within 6 months from the constitution of the tribunal. And on your screen, you see a general life cycle of the arbitration process for proceedings commenced under SIC Restructuring and Insolvency Arbitration Protocol. So normally, right, so the way we see this protocol is that generally it is recommended to parties by court, insolvency court or insolvency officer or different body of creditors. And then the parties enter into arbitration agreement. And then the constitution of the tribunal, normally before a sole arbitrator tribunal, as I mentioned. And then the award is made within 6 months. And then there is something here to mention, is that because this is very specific to insolvency and arbitration world, award may need to be, or there has to be some feedback back to the report, or the parties may need to report to the insolvency court about the resolution of their dispute. Yes, so the final slide here is just some of the statistical information on our procedural applications. Bear in mind that this doesn't provide information on cases that we administered in 2025. That's something that we will have annual appreciation event soon, next month. Yeah, so this is what I wanted to cover in my presentation. Again, thank you so much for the invitation, and I wish all the best to all the teams in that Primut in Poland, and of course in Vienna or in Hong Kong, as the case may be. I don't know if any of you are going to Hong Kong, but if you are, some of us will be in Hong Kong, some of us will be in Vienna, and please say hello. And of course, if you happen to be in Singapore, get in touch with us, come to SIC's office, and we'll be delighted to host you. And if we have some time, I'll be more than happy to answer some questions. I will not be able to answer Vismut related questions. I'm sorry, but yeah, thank you again.
Thank you, Vako. Do we have any brief questions from the audience? All right, we have.
Good evening. Greeting you from Free University of Tbilisi, from Georgia. At first, I would like to thank you for the information that you provided about the innovations that the SIAC provided. I have a question regarding the coordination procedure. You mentioned that coordination procedure is used when joinder or consolidation is not sufficient. However, I couldn't quite understand what is the actual commercial purpose, to say it in that way. Like, what is the commercial purpose behind using the coordination procedure, like hearing and concluding the proceedings concurrently or simultaneously?
Thank you for the question, and I'm delighted to hear that the teams from my country are participating in the pre-moot. So you are right that coordination proceedings make sense only if in the cases when either joinder or consolidation is not appropriate or cannot be granted for whatever reasons. There can be many reasons why consolidation or joinder may not be appropriate. So the reasons why, commercial reasons or legal reasons why parties may wish to apply for coordinated proceedings can be the same as in case of consolidation, which is to avoid any inconsistent decisions. If somehow both these or two or more arbitrations involve common questions of law or fact, and for whatever reasons these arbitrations cannot be consolidated, parties may decide to apply for coordinated proceedings, again, as an example, to avoid contradictory decisions in both of these arbitrations, in two or more arbitrations. That's one of the examples why coordinated proceedings can be applied. Again, it's a case dependent, and it dependent on the specific facts, specific issues that may be involved in these arbitrations. But the rationale or the reasons why the party may wish to apply for coordinated proceedings, again, because sometimes consolidation may not be granted. As an example, for instance, the arbitration agreements may not be compatible, and then this consolidation just may not be appropriate.
All right, do we have any more questions? Okay, maybe one more. Here we go.
Good evening. Thank you very much for your presentation. We're from the University of Geneva. And my question is about the streamlined and expedited procedure. So since the award is issued at a very early time, does the quality of the award still maintained compared to a normal procedure? Since they're issued so quickly, is the quality still the same? Or how can we guarantee that the quality of the award will be the same? Thank you.
Thank you for the question. It is a great question, and then I mentioned something about scrutiny process, right? So scrutiny process is applicable and applies to all awards, including awards that are issued in streamlined procedure as well as in expedited procedure. What I can tell you with full confidence is that the quality of awards issued in streamlined procedure as well as in expedited procedure are absolutely there. They are of high quality. And then again, the idea of scrutiny is that if, let's say, we see that we need to draw the tribunal's attention to the points of law or something, we will always do that so that we can enhance the quality of arbitral awards. But based on my experience, I can say with full confidence that even though the timeline is quite tight, both in expedited procedure as well as in streamlined procedure, the quality of awards are generally high. And there is something that, let's say, the streamlined procedure, something to mention here is that, let's say the streamlined procedure is granted or expedited procedure. And then in the course of the arbitral proceedings, it turns out that the case is actually more complex than it was anticipated in the beginning of arbitration. There is, of course, the possibility to take the case of either streamlined procedure or of the expedited procedure in consultation with the parties as well as with the registrar. So yes, I think again, in my experience, the quality of awards are high, and then the scrutiny process, we always try to enhance the quality just to make sure that these awards are enforceable across many jurisdictions.
All right. As we are running late, Vako, very much thank you for answering all the questions. And once again, let's give Vako a round of applause for his presentation. And
Thank you.
questions.
Thank you very much.
So, as we are running late, please could we meet in 7 minutes, so 3:45. Thank you. All right, so we resume after the coffee break, and let us now move to our second discussion round titled How to Prepare a Company for a Dispute Before It Arises. And yet again, we are joined by a panel of distinguished experts who are drawing their expertise from both law firms and in-house counsel's perspectives, and will discuss how to effectively prepare a company before the dispute arises. And today's moderator is Monica Diop from Clifford Chance. Please welcome our moderator and all of our speakers.
Thank you, Janek. Hello, everyone. Good afternoon. I think we are very privileged to have another panel on cooperation between law firms and in-house counsel. And I'm very pleased that we have a well-balanced panel today. I will introduce them one by one. We have two in-house counsel, Maria Dudzińska and Dr. Barbara Skardzińska. Maria is an attorney at law and specializes in avoidance and resolution of commercial disputes with a focus on business relationships and conflicts. And she's currently a general counsel in Ekoenergetyka Polska S.A. And also a member of the arbitration committee of the Leviathan Court of Arbitration, one of the biggest arbitral institutions here in Poland. I know she's also passionate about mentoring the younger generation and has for many years coordinated the organization of the biggest moot court in Poland for the bar trainees. And in 2024, she was included in the list of top 25 women in business lawyers by Forbes Women. Dr. Barbara Skardzińska is a legal counsel with over 15 years of experience in corporate law, M&A, commercial and financial transactions, and also dispute resolution. She currently serves as the chair of the supervisory board of Trakcja S.A. and is a general counsel at PKP Polskie Linie Kolejowe, so the Polish railway lines. Over the past 2 years, her team managed the largest dispute resolution activity in the company's history, including 27 settlements, so that is a nod towards the previous panel, valued at approximately 200 million euros. Previously, she worked in top-tier international and national law firms, has studied or conducted research at over 25 scientific centers worldwide, and outside of her professional work, she also mentors young female lawyers and is also listed by Forbes Women as top 25 women lawyers in business. On the other side of today's panel, we have two partners from law firms who had dispute resolution practices. We have Piotr Biernatowski, who is an attorney and partner at GP Partners, where he leads the dispute resolution practice. He's a recommended lawyer in dispute resolution in international rankings such as Chambers and Legal 500, has a dozen years of experience in dispute resolutions and corporate law, has handled disputes with over total value of almost 1 billion euros, and most importantly for the younger generation, is a co-author of the best-selling book, The Little Book on Drafting Pleadings, How to Communicate and Argue in Writing, which sold in over 10,000 copies, so I think you guys can try and buy a bit more. And last but not least, Łukasz Wydra, a PhD partner at Jabłoński, Koźmiński i Wspólnicy, heading the arbitration practice of that law firm, and also an assistant professor at the Faculty of Law and Administration at the University of Warsaw here, where he teaches civil law in international academic setting. He also serves as the chair of the Arbitration Commission section of the Warsaw Bar Council. His professional experience focuses on arbitration and complex disputes before state courts, and his experience also includes work for international law firms and as an in-house counsel for a global company. He regularly publishes and participates in scholarly conferences. So I'm very privileged to have this panel today to discuss how to prepare a company for a dispute before it arises, and I think in our panel, we will focus also, of course, on arbitration proceedings, but more about how to prepare before a dispute is actually ongoing. And just to set the scene a little bit, I was recently involved in a case where a company respondent was sued for damages in relation to a failed transaction. And the claimant filed multiple witness statements describing the intentions of the parties in that transaction, the execution of the documents related to the transaction, and why the transaction fell through. And we, as the respondent, had nothing because years go by, approximately three years passed since the transaction fell through. The client came to us and it turned out that all of the relevant employees are no longer on board. And actually some of them were even terminated for a cause in like disciplinary manner. So they are no longer friends of the firm. So we did not have much to work with. And as a result, it was very difficult for us to produce a coherent narrative. Of course, we did our best. But my thoughts then was a bit, why? Why did that happen and whether this could have been actually prevented? So in this context, I am very happy to start our discussion today with the importance of preparation. And I first direct my questions to Łukasz and Piotr. Why do you think it's important for companies to prepare for disputes rather than only react to them once they start?
So thank you for passing the mic to me. So it's a great pleasure to be here. Welcome and good afternoon to everyone. Well, I will expectedly you are here to listen to some pro tips. So, well, if I'm not mistaken, then my understanding of the purpose of today's conference is fine. So let me dwell on some tips and where main purposes why you should be more focused training as young arbitrators or developing your arbitration practice and being focused on mainly for what I've experienced, three main factors anticipating any arbitration. So first, well, you mention or even somehow consider why it is crucial for future arbitration. Well, it's always better to attack than to defend. So be proactive. And by proactive, it means, or I mean, when you connect with your financial CFOs or financial services of your company or your client, depending on the role, from your particular perspective, which means you are able at first to establish or develop the financial reserve for the whole dispute. And at any stage, well, irrespective of whether it anticipates or is established at the stage of a dispute. Then you are more prone to prepare or to somehow establish strategy, how to handle this particular dispute. Last but not least, what is meaningful is that you can always avoid or at least mitigate the risk of missing some part of evidence, which is essential. Many times I have witnessed disputes or counterparts who were missing evidence, and at some point of your career, you will witness or experience, well, I'm not wishing you bad, but surely you will face that at some stage of your careers. So at some point, surely you will meet the statement of either arbitrators or state court who develop or elaborate on, well, not submitting some part of evidence. And I believe that anticipating and establishing strategy or even triggering the entire process of collecting evidence, it's that practice which at least at its best might mitigate that risk. So thank you for now.
Piotr, do you agree?
Of course, I fully agree, because without evidence, no one can win any case, right? And that's a given. And speaking of both of the topics that you have initiated, we, as a pro tip, in many cases gather testimonies of the current employees who might in the future be former employees, not in the best relations with our clients. And we just tell them, hey, in a couple of years, a year or two, you won't have a fresh memory about what you have done on this project. And it works as a reminder for them that they have given testimonies and they shall not give other testimonies in court, because they might change their attitude towards the client that we represent. That's number one. But speaking of preparation, we should actually define what preparation means in terms of preparing to disputes. And for me, the preparation starts with drafting contract and I believe that the best practice in contracting is to involve at some stage, the earlier the better, dispute resolution lawyers, because we see problems everywhere. That's why we are not good entrepreneurs, that's the joke. It's hard to do business with dispute resolution lawyers because we only see problems. That's a given. So basically that's number one. Number two, gathering evidence. And number three, what is also important is the decision how to manage dispute like pre-litigation, in pre-litigation phase, including decision to enter the dispute, initiate the dispute as a first party, right? Because if you sue as the second party, the optics are different than if you initiate the dispute yourself. So that's also an important decision and very important in preparation how the case will go.
Maria, from perspective of an in-house counsel, what do you think are the common pitfalls for the company when it faces a dispute and was unprepared?
Thank you, Monika. And I don't think I will say something new with my colleagues, but as you said, the first thing is to be prepared to have evidence. There is an expression I used to hear when it comes to construction disputes. In Polish it is z kwitami to każdy głupi umie wygrać, and in English will be something like even a fool can win with documents, with the evidence. So I think this is true, right? Because every story we need to have during dispute also needs the background, the documents, the evidence, the witnesses, and this is, I suppose, the clue. So I totally agree with you, and I think the main troubles companies have is that usually or sometimes we don't have the database and the retention of the database, yeah, and the evidence. So I think this is the main thing the companies are facing.
Basia, what's your perspective on that?
It's hard to add anything to my previous distinguished colleagues, but from my perspective, I would say that the most common mistake is not expecting a dispute at all. Many companies just believe that the relationships and cooperation will go smoothly and well, and they do not prepare for the conflicts. And what I mean by that is that sometimes companies do not have clear rules how to keep documents, especially documents, we talked about it already, and later they have problems with collecting evidence. They have no clear procedures regarding the monitoring of obligations under some agreements. So in simple words, they are not prepared, and if they are not prepared, they pay 3 times. With money, with time, and of course with business relations. Because I think we all can agree here that court cases are long, expensive, and complicated. And very often they just damage the business relations. And in relation to alternative dispute resolution, another problem from my perspective is misunderstanding what it really is. Some parties treat mediation and negotiations as a courtroom, so they fight and they try to prove that they are right. And so we know that it's not the best, I would say, mindset. It's better to find a common ground and like a best solution for both parties that both parties are willing to accept. And I have something to Piotr to say. My previous boss told me that only Polish people had problems. There is no problems in your life, only challenges.
That's a very good point. And for those of you who are present at the previous panel, there was actually a statement that settlements should always be more prioritized than going into court, because some in-house lawyers hate disputes. And of course, we as disputes lawyers, of course, love disputes, but we are there to help, not to force arguing when it's absolutely not necessary. So still staying in the realm of your perspective as in-house counsel, Maria Barbara, what internal processes or systems have you found to be most effective in identifying a potential dispute early? You mentioned that it's sometimes that's the biggest problem, that nobody actually expected a dispute to happen. So I was wondering whether you have any processes or systems that you found useful.
Thank you. As this, I think every organization has its own idea to do this. In my company, we have the special procedure, and to see where the problems will be. So, in my opinion, is the most important thing is to catch the sparkle before it becomes a fire. So usually, I suppose the legal office and the legal team is the place or the members of the team who should be aware. And currently in my organization, in our procedure, when any letter with any claims or any, for example, unhappy client is showed, all members of the team know that they have to put it to the legal office, yeah, and to submit it to us. And then we are thinking if this is something that will cause problems in the future, and it will bring us to the court. And we usually start the negotiations with the business, with our colleagues from business. Sometimes the lawyer is needed there to be a part of the meetings, sometimes not, because sometimes it's good to have lawyer in the back seat, I would say. And for example, in technical issues, we just want us to add our emails during the correspondence with our partners in the not shown copy. So, but we can still know what is going on and to react. And I suppose this is, of course, there will be some problems or some situations we can't catch in this way, but usually when it comes to such situations, the legal team can react earlier and can, for example, think with the business about the resolution of the problems, for example, our client or customer show us. So I think this is the maybe something to improve answers in the future to the disputes. And sometimes we really have very good resolutions for that situation. And for example, we are then in the end just needed for make a settlement, right? And usually this is the end and nobody is going to court. So this is the best solution for the company, I suppose, from my point of view and from the in-house lawyer perspective.
I agree. Probably you know that state-owned company like mine is sometimes over-regulated, but still I would say that the most important thing is to have a clear internal policy for a dispute resolution or alternative dispute resolution. For example, if you want to have a mediation in the company, there should be a rule or at least strong recommendation that we are willing to do it. And in my company, we adopt such policy 2 years ago. It sets clear rules and steps to solve conflicts at very early stage. Of course, at the beginning, we have some challenges with interpretation of the policy, but at the end, we know that the rule is that we need to go for a mediation before going to the court. From my perspective, the most important thing, like really, really the most, is to have a support of the management board and the supervisory board. And if they say that it's okay, that mediation is just simply good for a company, you are like a winner already. And because in the end, it's their decision. They will be finally having responsibility for that decision. And yeah, it's generally good to have a general belief in the company that this kind of dispute resolution is good for a company. And I think that thanks to that approach, we have a success in the mediation. I can tell you that in the last 2 years, we saved like 2 billion zlotys in disputes, and that savings is a difference between the initial value of the dispute and the final value of the settlement reached by both parties.
That's impressive. That's really impressive. And Łukasz, Piotr, does that agree with what you advise your clients on setting up certain early warning systems or risk management processes so that they spot these issues before they become a fire?
Yes, let me start with an anecdote, which is too late warning system. Once me and Maciej, we've received a call, and the potential client told us, you guys must come, we have an issue here. It was a couple of 100 kilometers away from Warsaw, but yes, we went there, and there was a table, nice dinner, and we had a discussion about the construction contract that was going through hard times. And I'm always like, trying to figure out how to not to offend someone, not to be very judgmental. But Maciej, on the other hand, is very frank and straightforward. And hearing the story, yes, we balance each other. So Maciej at one point told them, so why the hell did you not terminate the contract? And the guy sitting on the side, I'm sorry, said at this moment, I F-word knew it. And he was the owner actually, and the management board was all in red. And the key takeaway here for us was that management board was not managing the contract well, and they were not interested in escalating the issue to the owner, who was financing the whole party. So that was too late. So the key takeaway is that the issues should not escalate based on PMs, standing for project manager, or RPs, standing for responsible parties, discretional decision. So there should be a criteria that tell everyone when to escalate, or there should be a specific time framework when to control how the contract is going. So those two types of effective, in my opinion, control system are not contradicting each other. They can be used at the same time, and they function the best when they are used at the same time. So that's how I see it.
I believe there's always room for improvement, well, especially if you function amidst in the middle of a structure which is a corporate or a company or an international even corporation. And well, from my perspective, I have developed certain habits. So, well, including drafting or constituting internal policies, which is, well, pretty comfortable to my clients, well, at least it was back then when I used to work for an international corporation. And well, for instance, we have developed at least 2 standards. One of them, where claim was for damage, it was essential, and well, and I established that standard while cooperating with my financial services, because well, it was our hands-on experience that well, after if we had initiated a dispute after the lapse of 2 months since an invoice was delayed, it was barely possible, well, even after winning the case, to enforce the award. So this is essential. So, well, my personal advice, if you have or litigate or arbitrate and you have to deal with a claimant for payment, well, it's essential to investigate and to identify, well, what was the deadline for payment for your counterparty, and well, if so that said 2 months hasn't lapsed. Otherwise, you might have a problem. And when it comes to, well, non-pecuniary claims, and disputes which were about, well, and where the matter of dispute was different than payment, it was essential for us to train or to tutor my colleagues from the company to identify risks at the level, at the stage of performing contracts. And I have reviewed dozens of investment contracts because, well, our company, our factory, our plot, well, had that mode of working constantly, well, except for 1 month where all those repairs was necessary. So, and besides that, for the whole 11 months, we are supposed and expected to work constantly. And it requires adjustments, repairs, and something like that. So, well, I had full hands-off job. And simply because of that, I needed to do some workflow, not only with contracts, but also I wanted to train my colleagues how they should operate in case of, or when facing any obstacles in performance of contract by their counterparts. So at least at those 2, or in these 2 spheres, we developed certain good practices, I believe, and well, as far as I know, well, it still hasn't changed. So, well, they kept those practices. And it was very facilitating for the whole staff.
It seems like a very useful thing to do. Of course, sometimes it requires a lot of work, but ultimately it's worth it because you might save 2 billion on it. And it was also mentioned during the previous panel that it's somewhat useful to involve disputes lawyers early on in like review of contracts or drafting contracts, even without a view of a particular dispute yet, just for them to explain how things may go one way or the other with reference to each and every provision. So I think it's good that we hear these systems are being set up. And Piotr, can I ask, what do you think is best for collaboration between in-house counsel and external lawyers to ensure that these systems are in place and that the company is well prepared? Any particular advice you would give in terms of that collaboration?
Well, what you have said already, like dispute resolution lawyers, meaning external counsels in this example or this question should be involved in at least reviewing contracts before they are signed. You know the joke about horseshoe? No? No? A guy goes down the road and looks down, and there is a horseshoe, right? He picks it up, and there is a horse beneath the horseshoe, right? So sometimes there is a clause in the contract, but when you have all the experience from litigation, etc., it might be a horse. So basically, it's a good idea to involve litigation lawyers in contracting, and then again let's say giving the framework for controlling how the contract goes, especially in long-term contract like construction contract, IT contracts, especially when the result is supposed to be tailored for the investor, for the party who pays for the provision of services. And and finally, litigation lawyers should have a saying, in my opinion, whether or not to start the litigation first, because it sets the stage on many occasions. As we know, the history and the cases are in many situations open for claims from both sides, and who sues first, like, has an upper hand, because the other side is seen as the party who is responsive. So why haven't you sued if you feel damaged, right? And it's a challenge to change those optics in front of the tribunal or in front of the judge. So that's number one. And lack of decision making within the spectrum of starting litigation is also a decision. No decision is a decision not to start litigation, which might be detrimental. So having said that, I think that legal counsels are closer to the clients, and they play a vital role in setting up the stage for external lawyers like myself or Łukasz. I don't know if you agree.
Well, if I may just slightly contribute to this point, well, because I feel as if I were sitting on the fence, well, being split between a former in-house lawyer and now when I advise as an external counsel. My main point is that, well, sometimes that cooperation between external lawyers and in-house lawyers reminds me of tug of war. So it's, you know, pulling that rope, and who wins, who prevails wins. So, well, avoid this approach because, well, it's a wrong attitude. Well, I personally, well, irrespective of my past serving as an in-house lawyer or now, I come with open hands, so I don't need to prove anything to my, well, in-house colleagues. But sometimes I had that experience that, well, when I used to hire some outside lawyers, they stared at me and like, what are you doing? Well, we are from a law firm X, Y, and Z. Well, it doesn't matter. And, well, at least a few times I needed to somehow to confront, but I've always been polite. So when it comes to, well, said cooperation between in-house and external lawyers, what is essential and meaningful, and there is, and here communication is second to nothing when it comes to your cooperation, because, well, you have to take into the account that in-house lawyer is your ally and not your enemy at every time, on any occasion. So, with no exceptions. So imagine litigating as an external counsel when you ask your client for evidence. Who delivers that? In-house lawyer. Head of legal is the one who at least appoints one of his peers, of subordinates, to support you at this stage of collecting or gathering evidence. Well, you might have also that pleasure to cooperate with financial services or, well, something what we called the business, but, well, in this case, mostly, well, your first milestone is the in-house lawyer. So which is why it's essential, it's crucial to build a really good and sincere relationship without said tugging of war. Thank you.
Say one thing, just one thing. I really like your comment. I would also like to add that the in-house lawyer, like general counsel, take responsibility for a work of lawyers from a law firm.
I wanted to add to what Łukasz had said, that I personally like to work with in-house counsels because they understand our language. Good in-house counsel is very helpful if we start our work and throughout the whole process, meaning that if we work directly with management boards, for example, it's more difficult to, explain them all peculiarities of the disputes, why we need that, why we should gather that. Yeah, in-house counsel are the best clients.
Maria, do you agree? What are the key
yes,
elements?
I totally agree. Maybe because in previous lifetime, I spent about 10 years in the law firm. Yeah. So yes, I totally agree that from the external counsel perspective, the in-house lawyer is the best partner to talk because, as you said, that we speak in the same language. And I also want to add to something to this you Piotr told, that it's good to be the first party who's starting the battle, yes, who's starting the dispute. And I would also add from my now legal counsel perspective, for the internal, the in-house lawyer perspective, that sometimes even we don't have to start the real action, we don't have to sue. Sometimes we just need to aware the other party, we will. And from the in-house counsel perspective, we can do it in various ways. For example, if we are helping to draft documents like letters and statements, answering the statements of the other party, sometimes we add there the sentences, the things that the other party will understand, that we are ready to go to the court. Because sometimes, and I know it from my experience, sometimes the other party is thinking, oh, maybe they will not, or nobody wants to go to court, and so on and so on. So sometimes it's good to aware the other party that we can go to the dispute. And just answering your question, Monica, I would say that the ground for good cooperation between external lawyer and the internal lawyer is to, of course, to have trust, to speak in the same language, as we said, but also when I'm now working with the law firms, I would say it's good to say to the external lawyer what I need, because sometimes when the dispute arises, I just need the short opinion, just to catch the ground, to catch the overview, and just to have, I would say, main ways to just to make the decision or just to go for the decision to my management board. And sometimes I need the whole background and the full legal opinion. And I suppose it's very important to know, from my perspective, to know what I want from my external lawyer and to communicate it. And I will quote you, Monica, because I remember some time ago, during the other conference, during the panel, you said something that is very with me. You said that communication and transparency, those are golden rules for cooperation between internal and external lawyers. Thanks.
I can only agree with that. I mean, I'm just listening to all of you, and I think one of the best feedbacks I ever got from a client was that they appreciate that we are not reluctant to kind of tell them the truth, or, instead of telling them, look, you have such a great claim, let's just start litigation because you will win for sure. They really appreciate hearing that, sorry, it's statute of limitations passed, or you really are not going to win this, or consider settlement because at this stage it might be still a possibility, whereas once you start and the other side sees your evidence, it might be too late. So I think transparency and communication really does that. And I think it was also nicely put by someone in the previous panel that it's really important to kind of make the in-house lawyer part of your team, as when you're preparing for a dispute or doing, you know, preparation of a submission or arbitration. Of course, it's not to put the weight of work on the in-house lawyer, but for them to feel that they can communicate as if they were actually a team member, and they can point out all of the issues that they think are necessary or not necessary, and point out all the arguments. To tackle the evidence point a bit more, Maria, you also, I know we discussed it a little bit, and you mentioned that today earlier. As an in-house lawyer, I know you have a perspective on what practical steps one should take to ensure that relevant documents and evidence is preserved. And I wanted you to share your perspective on that with us.
Yes, of course. As I said before, it's good to have the kind of procedure to catch the situations and the cases when the fire can arise. And it's good to involve in-house lawyer and to have it in the loop, and to have it during the negotiations with the client, because usually there is no, I would say there are no big disputes without some backstage, right? So without any signals that something will be something will be there. So usually I do my own in the legal office among the legal team. We usually have the own database. Sometimes we even when we are drafting the emails, our colleague from business are sending, we know that those emails will be needed during the dispute, and we collect them as a legal team. So I think this is important to have, maybe not all the things that are connected with the future dispute, but to have the main documents, and also to, I would say, to navigate them and to help our colleagues to, for example, write to the other party things that we will need in the next stage. So yeah, I would say that.
Fully agreed from a perspective of someone always looking for those emails. Well, Piotr?
I can say it's it's not always it's a success, of course.
Yeah, of course, to be able to preserve that. Piotr, Łukasz, is it something you advise as well to kind of have document retention policies in place and what they should specify to your clients?
Again, maybe too many anecdotes, but it's a true story.
Never too many.
It's a true story that not only evidence, but always keep your arbitration clause. And actually, we have won an arbitration for a substantial amount of money, and the client didn't have arbitration clause. But we requested for payment, and the other party paid. I will not give you any more details because I don't want anyone to have a heart attack, and we are on camera. But always keep your arbitration clause close. And speaking of the evidence, obviously retention is essential, and another story is that the mailbox of one of our clients' PM in huge contract was deleted because he was transferred to another company owned by the same owner. So basically, he changed his job, but he didn't even leave. He left for he got another job in another parent company, and the whole mailbox was deleted, and the whole story of the projects from our side was diminished. So it was very hard to recover, like impossible. We had to go around it, and with bigger or smaller success, we managed to substitute that piece of evidence with other. But you never know how the dispute would go. It was arbitration and in ICC, and we will never know how it would go with this piece of evidence. So retention is the key, and I think that that even in big companies that have great policies, etc., etc., it's always about the people, right? And the procedures are on many stages have to be followed by people who are not lawyers, and they treat legal stuff as necessary evil, but sometimes you have to tell them that it's kind of important, and come on, let's do the small steps to not to start domino bricks to follow one after another.
Okay, let me share some stories again. So I would like to give you some stories where at least one or two are personal and the third one is not. So, well, first, when I joined the company as an in-house lawyer, I had to face certain litigation, but we were the claimants, so it was not a big deal. But I was surprised because, well, my ancestor or previous legal advisor, legal counsel's approach was well, an invoice was a sufficient evidence, you know, to win a case. So it was like, well, from my perspective, for what I had experienced before joining the company, it was a new invention, but it was, I realized that I need to change this practice because it's always risky to base only on an invoice when you claim for money. So don't do this, definitely. So here's my first pro tip and my first personal story. The second story was that luckily there was a lady just before her retirement who, well, irrespective of keeping, you know, and uploading all those emails, she had, well, her own habit, which was to print everything. So it was really, well, it might seem funny or even amusing, but well, from my perspective back then, when I'm joining the company and I need to initiate, well, at least 3 proceedings for payment, it was a really good contribution and a really huge benefit because I was able to collect the evidence within, I don't know, 5 or 10 minutes, because I just asked the lady and she brought me those printed documents, which was really beneficial and facilitated the whole process. The first story, as promised, well, it won't be a rocket science, but well, be careful with documents, because when I used to be a legal trainee here at the Warsaw Bar, one of older colleagues shared that story, that there was a guy who wanted to review court files. So he orders court files, well, to the reading room in court, goes there, and what he does is he eats the act of will. So, as you know, it's really hard to recreate the act of will, well, and especially considering the fact that it must be handwritten under the Polish law. But what is essential and the final point of that story is that be careful what you do with your hard copies.
Not only can they be destroyed, but also lost or eaten. Maria, I know you have something to add.
I just wanted to add something because, of course, it's a perfect situation to have statements, letters, even emails and witnesses. But yes, sometimes we face the problem when it comes to the dispute and where is the agreement. So it's yes, it's really good to have it all, but sometimes we are facing the situations that even arbitration clause is, we have to found it inside the organization. So yes, there's a problem.
So from that point, I think it's a nice segue to discuss training and awareness, how to build it in a company. Is it important? Does it work in practice? I know Łukasz, Maria, you have some examples of whether it works or whether it can be effective and how to make it effective.
Well, it's a broad question because, well, when it comes in general to the cooperation with people, well, especially from the perspective of an external counsel, it's harder, I guess, to transpose somehow my habits, my practices, my approach into company, because I'm only an external counsel. So who I am to order or to ask someone. So if there's no will on the other side, well, it will simply collapse. And so which is why cooperation is so meaningful at any stage, and not only between an external counsel and an in-house lawyer, especially head of legal for each and every company you will meet in your career. So, well, my personal approach is that if you want to govern and if you want to somehow develop good, better, and finally the best practices in a company, well, at first you might convince those to whom you will address your recommendations that they will benefit from that. Otherwise, it will fail, simply. So, and without communication, without, balancing between possible setbacks and benefits, there's no option you will introduce or tutor your clients or colleagues, because, well, I personally consider in-house lawyers with whom I cooperate on a daily basis as my colleagues. So I don't consider them as extraterrestrial bodies with no links to me. No, it's quite the contrary. So my perspective is that, well, we work together, we are in this ash together, and if we win together. If we lose together, which is the best part of that job. So I wasn't the one who lost the case.
And maybe to shortly add something, I would say two things. So one thing is to communicate with our colleagues from business and just to explain them why we need it, why we need them to act in some way, and what to say to the other party and what to not say, and what not to write. And the other thing is to maybe just to show them that the way that we are acting as lawyers is really helpful to them to have in one hand to have good relationship with the client, and in the other to also have to be prepared when it comes to just have in mind the interest of the firm, right? Because at the end of the day, we as lawyers and our colleagues from business as a business, we have the same goal. So the thing is not to have claims, of course, but sometimes when the other party, for example, during negotiations is too hard to not agreeing with our point of view, sometimes it's better to let it go and maybe not to go to the court, but think about the dispute. And sometimes this harder actions and some harder words even during the negotiations are helpful to have better resolution to our company. Yeah, so that's all. Thanks.
Thank you. And from the perspective of a state-owned company, any particular challenges or requirements you would like to share?
I think that many disputes do not come from bad intentions. Most of them are made on the basis of decisions which were made without full understanding of all risks. So trainings and increases awareness, that's for sure. For state-owned entities, we have additional, of course, challenges because we must follow very strict rules on public money and due diligence. So there's something what is called public finance discipline. And if there is no training or no clear procedures, for sure, it will be criticized by our supervisory authorities. So for us, for state-owned companies, good preparation is not just a good practice, it's our legal responsibility.
Fully understood, and I think that this should be the practice adopted by also the private companies, just because it seems to benefit benefit everyone. Before we conclude, as we are focusing on disputes in this conference, and it seems difficult not to touch upon dispute resolution clauses or general drafting. So, Łukasz, Piotr, can you maybe comment on how can companies use these clauses to minimize the risk or prepare for potential disputes? You also referred earlier to participation in drafting, so any more points on that?
Yeah, well, summing up or reviewing or observing my every year, I must say that, well, there's no week without any counseling, well, from my perspective, on how an arbitration clause should be drafted. And I could have shared many stories here. Well, starting from my colleague calling me and, you know, he thought he had an arbitration clause drafted where there was an exception because, well, they forgot to mention the court, the arbitration court, so it was a slight detail, and, well, they wanted to go to arbitrate without indicating an arbitration court. And, well, even 2 months back, I made an award together with my co-panelists, co-arbitrators, where I umpired the panel. And we had a really complicated situation because, well, the arbitration clause was based on dated legal state of act. So it, you know, the old Code of Civil Procedure. And in that case, what we wanted to do, we wanted to issue the award, and but in this case we decided to do something which was risky and I believe unprecedented. We asked parties to redraft an arbitration clause as arbitrators. So guys, and it was an ad hoc arbitration. So in this case, guys, if you want to have or this issue made, and it was an arbitration between 2 state entities. So, and yet still they wanted to arbitrate. So simply because of that, we wanted to mitigate the risk of challenging an award or, you know, issuing or making an award which would be unenforceable from that perspective. And yeah, and simply because of that, but thanks to the cooperation of legal professionals who behave professionally and redrafted the clause, we were able to make the award, and as far as I know, it wasn't challenged. So there were no objections addressed, well, either to arbitrators or to the award. So this is my experience, but when from the perspective of drafting arbitration clauses, well, beware. My main pro tip, to make this long story short, is, well, the shorter the better. Do not work on and elaborate or arbitration clauses, because I won one of my first arbitration clauses based on that the claim was beyond the scope of the arbitration clause. So you need to be very careful. Thank you.
On top of that, I might add that let's just remember that arbitration is an exemption from the right to have a case heard in front of the common court and have a ruling that the rule is that we should go to the common court, and the arbitration clauses are the exception, so they must be drafted carefully. And why is that important to choose between arbitration and common court? Because in common court, especially in difficult and multi-layered cases, the judges may not be competent enough to give a good judgment. I had again. It seems that there are so many stories that I refer to them at all times, but it's on top of my head. I had a judge that was I don't know. He was closing his eyes when I was challenging the witnesses, and I didn't know if he's focusing on or if he's sleeping. So that was a challenge. I was, trying to wake him up in a kind manner, but I never knew that if he was, so focused or so asleep. It was until the moment when we managed to get the management board conviction for unjustified for the wrongful. Sorry, I got up 5 times today to my newborn, so I'm running low on fuel. Apologies for that. So basically, there was no sugar. So my point is that at many times it's better to get arbitrators because you can choose them. You can choose them to based on their experience within the specific area. And in contradiction to that, we have, let's say, commercial courts in Poland, whose scope is very, very broad. My personal opinion is that we should have more specialized divisions within the courts. For example, for construction, 100%. For IT, as well. Judges should have 1-2 specific areas in which they really specialize in, and that would help a lot. And mitigate the difference, make it smaller between the professionals in arbitration and the judges in common courts. Thank you.
Fully agreed. Basia, Maria, do you have anything to add on how you work with arbitration clauses or whether you participate in drafting generally?
Usually copy-paste.
From the rules of arbitration.
From the rules, of course.
That's the best practice.
That's not a rule for me. We have always a huge dispute because arbitration clauses are mainly in international agreements with our partners from abroad. There's always huge fight about the court, where we are, which one we are going to choose. But I work for a huge company. We have 26 units in Poland and the headquarters in Warsaw. And our policy is that lawyer needs to sign every annex, every settlement, every piece of paper which has any obligation. So you need to, you can imagine what an army of lawyers we need there. So and where is a lawyer, there is always one opinion. So there's many opinions during drafting.
Keeps you busy. So before I ask you guys to conclude and share maybe some top tips, I must refer to a sleeping arbitrator case, just as a funny story, because it was also discussed at the previous panel whether people from external lawyers preparing for the hearing enjoy having an in-house counsel participate in the hearing. And someone said that it's harmless. Sometimes it's harmless. Sometimes it's more engaging. So in early days of COVID, we had this Zoom hearing, early days of Zoom, where nobody knew how to actually operate on Zoom. And we had a client participate, and one of the arbitrators fell asleep, or at least closed his eyes. Nobody knows what was actually going on. And the client used the wrong chat to comment on the fact that the arbitrator was falling asleep. So, of course, it was, a super awkward situation. So just, not that I'm, just to say that not that we haven't seen sleeping arbitrators sometimes, and kind of a final anecdote from my side. And before we finish, I just wanted to ask you whether you have any more examples or anecdotes to share, or any top tips that you'd like the audience to conclude with today in terms of how to improve being prepared for disputes.
I have two tips. I think that they sum up our discussion today. First is that many companies lose disputes not because they are wrong, but because they do not listen. And a few years ago, I have here in this building a wonderful training about active listening, so I highly recommend it for you to do these classes. And why listening is important, because without listening, you react too late and without a plan. And second tip is that you need to be always prepared, and every claim should be supported by good documentation, by solid calculations and expert opinions. It would be perfect. And some companies increase the value of the claim to get a better result. That's not a good solution, especially for state-owned companies like mine, because we need to show exactly why the settlement is better than the court judgment, and if the claim is too high, it's hard then to justify mediation rather than court proceedings. That's for me. So be realistic, be prepared, and listen.
So if I may, 3 personal stories. First, I also had a sleeping arbitrator in a panel. Unfortunately to him, well, no, I guess it was not the same guy in this case, but well, unfortunately to him, it was an on-site session. So, well, it was funny. Another story is that, well, back in my 19, when I was at the first year of the university, well, my roommates gave me a gift. So it was The Art of War by Sun Tzu. So this is the book I've been constantly reading every now and then. So time and again, I return to that book, you know, gathering certain parts of that. But well, to conclude, because the main focus of that book, of the author, was always to think 2 steps ahead. So this is my main advice. So if you are considering on behalf of your client or sometimes personally going to court or arbitrating, well, just try to be advantageous, be proactive. And so another point was about, yeah, the importance of preparation. So this will be the first story, because when I was, I don't know, 17, after being encouraged by my classmate, I bought the cassette. Well, some of you might not know what it was, but well, it still exists. So I bought the tape of, it was the 3rd album of The Prodigy. So, and there was that cover with those drawings, and I can quote literally their advice. So, preparedness makes us powerful, and butter makes us fat. Thank you.
Yeah, for me, something that is in our handbook, as I've mentioned, is always to get the testimonies of the witnesses, because you should never assume that the evidence at hand will be your evidence at hand in the future. Most surely it won't. Sometimes it will if the retention is properly managed, etc., etc. But speaking of retention, I also had a case where I defended a management board member, but he was in Australia, so the case was it took many years for the court to actually give a ruling. And one point when the files were at the court and the ruling was almost given, the court, according to its retention rules, destroyed all the files and wrote to me that that obliged me to provide all the documents about the case to the court because they are trying to restore the files. And as you can imagine how keen I was to provide all the files about my client who was defendant, right? So obviously in the criminal case he was a former manager of one of the companies, doesn't matter which one. So basically, never assume that the evidence at hand is, right now will be the evidence at hand in the future. So I won't give more details. I think that's the first and most important rule.
Anything else?
Almost nothing to add. I agree with you.
Mm-hmm.
Yes, thank you. Maybe sorry for repeat it, but I think it's important, and for me it's a good rule, just to catch the sparkle before it becomes a fire. I can say that it's easier to do it and to be prepared and to catch all the situation that can makes you that can follow you to the court. It's easier to do this being in-house lawyer, because in my previous law firm, when usually we were added to the situation when the dispute is already begun, and it's so much easier to help to the company being inside, and of course it's usually possible when you know your business, when you know your company, when you communicate with your colleagues from business, and I think this is the best resolution to have maybe not all cases in the court or in arbitration, but if you will be there, it's really you can possibly win. Yeah. So thank you.
I can only agree, and it seems like we would work well together on this panel in a real life case. And I'm just going to open the floor to questions if there are any before we close the conference.
Hi, so thank you for a very interesting discussion. And I have a question maybe first to the external counsel. So do you always recommend arbitration when a company approaches you to consult on a potential dispute? And in reverse to the in-house lawyers, do you always accept such suggestion?
No, not always. Sometimes it's hard to convince the client to go to arbitration because it's something that he's not very aware of. He haven't heard of it before, because big clients doesn't necessarily come from Warsaw, from big skyscrapers. Those might be entrepreneurs who have big businesses, but are very grounded. With all due respect. That's number one. And number two, sometimes if I'm about to represent the party for whom the complexity of the case and the length of the case and the dynamics of procedures in front of the common court would be, for whom it would be beneficial, it's not necessarily in my interest to go into arbitration where the case would be faster and probably settled in more, I will say it frankly, in more professional way. I'm not a huge fan of common courts. Obviously, there are a lot of wonderful judges, but the risk of getting a judge that is overloaded with work. I'm not pointing fingers at judges, please understand me, but they are really seriously overloaded with work, especially in Warsaw. So I'm not speaking personally against the judges. If any look at us right now, it's not about you. It's about, you know, the workload, the lack of assistance, and I understand them fully. Like, they have one life and they have families. You have to always consider the fact that you are not addressing someone who has a lot of time for you. So basically, I take that into consideration as well. How would the case go in front of arbitration tribunal and how the case would go in front of the common court? Thank you.
How much time do I have to respond to your question? No, but seriously, well, it depends on two factors. First, what type of client it is, and another, well, what's the purpose and what's the matter of the case? Because, for instance, arbitrability under Article 1157 has developed over time. So right now, with some exceptions, most commercial cases are arbitrable. And we are discussing only commercial, I guess, and I assume proceedings. So, well, mostly I advise my clients going to arbitration. And, well, especially if they ask me to support them in negotiating contracts, because, well, throughout my whole, let's say, career, I have reviewed over, I don't know, per 2,000-3,000 of contracts, so I know something about drafting contracts. And, well, not only from the perspective of a litigator, and I'm able to identify possible risks. However, well, let's get back to what type of client it might be. So when, for instance, you have a company listed on a stock market, well, it doesn't matter to them whether they win or lose the case. Why? Because, well, at the beginning of even preceding the dispute, they have to establish a reserve, a financial reserve. And sometimes it's more important to financial services, to CEO, to remove that from your balance sheet because, well, it may somehow reflect and interfere your stock price, which is more crucial to shareholders and investors. And from that perspective, it's in the best interest of a company and your client as well to remove that financial reserve as soon as possible, which means, well, I will tell you a personal story. So well, there was a day, it was Friday, so I learned that, well, my client was sued for 50 million zlotych. And it was a stock listed, a company listed on a stock market. So I spent a few hours discussing with my CEO, well, what are the chances of losing the case, for how long they will have to maintain the reserve, the financial reserve. Because from their perspective, well, 50 million zlotych in balance sheet, it's a pretty good stuff. And it's a pretty good amount, well, they needed or they had wanted to remove. So they were interested in going to arbitration. Well, however, luckily to my client back then, well, the claim was completely groundless because, well, it was a fictionally created claim against my client. So which is why I didn't advise back then going to arbitration because, well, it was right after, you know, adding that provision to the Code of Civil Procedure that an obviously groundless claim can be dismissed at a closed session. Well, unfortunately and surprisingly to me, well, the court didn't do that, but it closed the session and, well, the whole case at the first session, and we won the case. But, well, if I were, or if I had, you know, bigger problem with serious evidence and more seriously documented claim, I would definitely recommend going to arbitration in this case because, well, it takes you on average about 1 year. When you go to arbitration and after 1 year of arbitrating, you have an award with no appeal. So one thing you can do is you must do or should do well in case an award is not performed voluntarily after it's made, you must go to the Court of Appeals, mostly in Warsaw, and, you know, and receive that, well, seal, which is the execution, the enforcement clause. And, well, otherwise, you should definitely go considering to arbitration. Well, unless you have no option. But, well, right now, when you have this extended arbitrability of disputes, it's always, well, or at least in 90%, it's always better to go to arbitration.
one phrase of one of the panelists touched me thoroughly. It's all about people. And we had a question regarding the training, how to prepare the company, how to prepare our clients to the future dispute. So my question is, to my limited but still experience, a dispute is often a consequence of a mistake of a person. How to, often, not always, how to treat this person as a value, how to manage cooperating with this person after this mistake has been committed, business, legal mistake, irrespective, to treat this person as your ally in a dispute and in preparation to dispute, not a scapegoat. How to balance those two emotions, which are difficult, I think.
Emotions aside, the first place.
I think there is a good point in that question, because as I mentioned, for example, the anecdote where me and Maciej, we went, to the meeting. This guy was, putting all he could under the carpet as long as he could, right? Before Maciej's reaction and the owner's reaction when they fell in love with each other, and that was the fruitful of a long cooperation. But some kind of communication should be, in my opinion, done and performed, because those people are going to be witnesses as well, right? And if they are going to be very defensive and protect what they have done, and those kind of testimonies might contradict the interest of the company. So before that happens, you have to identify it and mitigate their, guilt, their risks. Sometimes give their some kind of waivers, right? In the end, they should be convinced that they will not be held responsible for what happens in the court.
Well, if I may, just to give you a piece of advice from that perspective, and just to shortly contribute to what Piotr has said. Well, you cannot act not for the purpose, but even unintentionally, to finally turn that person into your hostile witness, because that would be a mistake. You need help, you need support, and you need to solve a problem. So, but without any threats and and projecting any possible punishments. So this is my recommendation.
As I don't see any questions. May I have one? Very all right. Very short, yes or no one?
I would like to ask each of the panelists a question asking for an answer, me, them. Who shall lead in a cooperation between in-house and external lawyer? Who shall be a leader in this cooperation? Me, them.
General Counsel, thank you.
Agree.
Personal story again. Michael Jordan was asked once who should take the final shot, and he said, me, that's obvious, so me.
We call the shots and we take responsibility with all due respect to General Counsel, who are the clients, so basically they, but yeah.
All right. As I can see, no more questions. So once again, thank you very much to all the speakers and the moderator. Let's give them a round of applause. And to conclude, thank you to all the participants for contributing to the discussions and the exchange of ideas. And now, without the further delay, we transition to the opening of the 17th Warsaw Primut. And maybe one word from me as ex-Muti. To all the Mutis here, I wish you all the best in participating in the next 2 days. And just, I know it's hard, but just enjoy yourself because this Mut is a great journey. So once again, thank you very much. And I would like also to extend my thanks to all the sponsors we have. And hopefully we will see you next year. Thank you.